Testing, testing. What's happening, people? I added ASAP Rocky on up in the what smarter? I added ASAP Rocky on up in the lineup because I forgot. This is and then I'm not indicating that ASAP Rocky and R. Kelly is related. No. I'm just saying that it's going to be brief when it comes to those two. Um, but oh, it could be a briefing. How about that? But nah, but what's happening? What's happening, folks? Just give me 1 second. Okay. Listen, you know what? Your timeline, right? It just drives, honey. Pretty. I mean, this when I wrote this last year, about how YouTube is dictating pretty much what we input and what we output. Pretty simple. And in our timeline, they're giving us what they want us to know based on all those algorithms and whatever method they use to decide who should be watching what, right? They cross reference it, they link us together, they unlink us, they watch everything, Jack. What we unsubscribe to, what we subscribe to, all of that is what drives what they tell us that we should watch. Even if it's a suggestion, right? They actually really is telling us what to watch. Because unless we independently go out there and Google, or not Google, but YouTube something else, right? By putting something else in the YouTube search bar, it's going to populate whatever they want us to watch. And 9 out of 10 times, or 8 out of 10, maybe 7 out of 10, that's what we're going to watch. And that's what we're going to talk about or opine on, right? Right. So I have other sources other than YouTube, like most of us, right? However, YouTube is probably, well, let me change that because I'm doing a lot of Twitter. But I had to figure out how to use Twitter. You understand what I'm saying? Because it, if you compare it to YouTube, it's kind of generic, I guess, because it doesn't give you that many options and functionalities and things of that nature, right? And it's very, very um, it, there's not a lot of buttons to push. However, it be jumping. There be a lot of activity going on if you know where to go, and that's another thing. You got to navigate it and try to figure out how to do that. Um, just like the people how they be using Instagram and TikTok, right? But anyway, so some of the sources they be producing other content. And when you subscribe to a particular community like legal or home and gardens or whatever, that you're going to get sources and resources from those particular uh, those particular subjects, right? Within that platform. So I knew that Keefie D. Actually, I didn't. I didn't know. I didn't know the last time Keefie D went to court. I just got the law and crime update that whatever was denied, right? I didn't click on it or anything like that when I originally got it back, a few days ago, right? So when I got something from the Apple Podcast, right, they say they're the number one. I don't know, the number one true crime podcast on Apple. I guess it was about Keefy D, but more specifically, it was about what he had went to court for, right, which was corpus delicti. Okay, well, let me get some out of my mouth. Hold on, just 1 second. Okay, so they were more specific with it, right? Because 9 out of 10 times when you see articles or whatever, they don't go into detail what it's about. They just say it was declined, denied, or whatever. Unless you read it or whatever, you know, you're not really gonna get much detail. You know me, I hate to read, and a lot of times, sometimes when you do read them, it doesn't go into the legal aspects of it. When you have when you subscribe to specific, legal channels or legal resources or sources or whatever, they tend to go more into it, right? So anyway, I swear this is some white people shit. The Lipton tea with the peach and all of that. Like I don't do all of that. I keep it real simple. Lemon is the only fruit I'm dealing with in my drink, child. But anyway, so um, I didn't know that he TBD had at this, and maybe this was his latest denial. I would imagine so. It wasn't the data. I went and found the Law and Order, Law and Crime um, latest on Keefy D, and it was 5 days ago. And they were speaking on the corpus delicti, and I was like, huh? Like, why would they file that? You know, and here's the thing, right? Again, this is why R. Kelly was the last minute ad on this. And I said I was going to talk about, because every so often we need to check to see, what's his or whoever we follow. This is just in my opinion. whatever cases we're following or speaking on or whatever. I mean, I guess we should provide some type of updates or whatever, unless we tell you, nah, we out of this situation, whatever. Like, I think we pretty much out of that. Alec Carter's is, I don't know what the hell is going on with people. I don't know. But when I sat there and saw her talking about she's a Diddy victim, I don't know if I had put that up there before. Um, I don't know if that came out before, whether, I be putting so much stuff up there that a lot of times I don't read them. Um, some stuff, if it's legal, I really don't have to read it because I can pretty much, you know, speak on at least the process of it or whatever. I might have to get to the bottom, just find the results. But the the other part of it, I can just speak on, right? If I know it. So, but I don't know if that girl had said that before. I'm like, what is going on? And I said when it began to form up, I was like, this seemed like some Jaguar shit. So I'm still not sure if she with Jaguar, if she's off the Jaguar, or what the hell is going on. I don't know. But there seemed like a lot going on. It's a lot of weird shit going on. Okay. And when these weird people start wanting attention from, national attention and things of that nature, whatever, it really can get confusing or whatever. The person that said they were supposed to be on the Alec Carter situation, Mo, um, who, she be having 1,000 things on her plate too. I don't know if she was like, baby. So I don't know about that, y'all. But so y'all continue, anybody is more than welcome to upload us or download us with the information. I don't care, but I don't. That seems like it's going to take you to the abyss, right? I got time for that. Now, when you into it with on a whole bunch of other stories and cases and shit like that, and then you got what's going on with the world, the country, whatever, the world. So yeah, it's a lot going on, right? So when I saw that, I'm like, huh? Now she a Diddy victim? I'm like, ain't this some Jaguar shit before she walked the back? Like, anybody got time for all that? So anyway, but from time to time, I just think that, you know, if it's a midway or whatever, I think it's our responsibility to provide at least some information updates or whatever, or to come out there and say, oh, ain't no information updates on whatever stories and this and that we done put in your goddamn house, right? By way of coming up on this tube and presenting it to you, right? In one form or fashion, right? On the wall, up here in the video, whatever. And it's all, to me, it's all about, I mean, I just have my method of my madness. So, you know. But anyway, puberty, right? When I saw that it was a corpus delicti that was filed on his behalf, or should I say, if I'm speaking properly, that he filed, I was like, Now, huh? Okay. Now, when that is filed, right, the defendant is actually saying, that they cannot be convicted without evidence that a crime occurred. Now, I know there are some conspiracy theories that think Tupac and Elvis and Jeffrey Epstein and you know somewhere alive, right? I know that. We're gonna deal with the people that got a pretty pretty good feeling that those people are dead. When they died, when the people said they died. And I'll get into my fight with conspiracy theorists. And it's been a long fight, because you know where you meet most of the conspiracy theorists in class. That's where you meet them. And I've been fighting and arguing with them people since the 90s. Okay? When you take classes that has anything to do with history, science, especially science, the law, depending on which side they're going to, what side what track the person is going to take, right? If they're going to be a criminal defense attorney and they kind of are on the anti-government type thing. And remember, I'm in the South, right? So, you're going to run to a few of them along the way. And, yeah, in medicine, of course, is science. So, but yeah, but definitely science. Just about any class, any earth, whatever. There they go. Here they ass come. Here they ass come. Right? So, hmm and the schools, well, most of them that I was able to get in that accommodate students like myself have been, um, I can tell you that, but just know they accommodate students like myself. What else I can tell you? And they have a bunch of classes for the real bright ones. I wasn't in none of those. I was in the ones right up under that, though, some of them. But I was not in the real bright ones. I wasn't in none of those. Uh-uh. That was a high school thing, yeah. But, yeah. The ones that be at, them real, they, yeah, those, right? Mm-mm. No, I'm going to keep it funky, right? I'm going to tell you the truth about it. So you encounter some of those. But other than that, let's get back to this corpus delicti, right? Again, that means that the government must prove that a crime occurred. And you probably thinking like, well, damn, I mean, duh, right? Well, it is a real thing, right? It is a real thing. Um, and the government has to prove that the mens rea, right, which is the mental state, and the actus rea, which is the physical act, there is connection between the two, right? Alongside of a crime occurring. Yeah. So and they do this, right? And I'll tell you why I do it. So it's not a duh type of situation. They do this to prevent wrongful convictions by someone who confesses to a crime. Okay. So in some states, you can't convict a person just by confession alone, right? And that is true of the feds. But in some states, you cannot convict a person just based on the confession alone. Las Vegas is one of those states. So I did a little homework. How about that? I don't usually do no homework. I don't read nothing before. I don't do none of that. Yeah, but I wanted to see, right? Because I wanted to see. I'm just checking out the PPD's attorney. I'm just trying to figure out where he was going with this. That's it. So I mean, that's what I was doing. To be honest. So um, and you have some states that will allow a confession to stand on its own without evidence to support that a crime has occurred, right? So yeah, and I was like, okay. So whenever a corpus delicti motion enters the courtroom, the government, and I consider, which it is, anybody prosecuting your ass. That's the government. Now there's different levels, right? So I like to, just keep it broad and use the government, right? No matter if I'm talking about the state or the actual feds. But when a motion like that enters into the courtroom, the government automatically knows that they have to show that one, there was a mens rea, which is the mental state, the actus rea, actus rectus, which is the behavior, the act, the activity. Okay. Also, that the mental state and the actus reus align, right? It aligns, it's congruent. Also, the causation, which is, remember that long time, this is before I even got a channel, I'll start telling you about that, right? Causation, right? Meaning the accused has to be connected to the result, right? The whatever happened in the end, the crime that was committed, right? And then it also has to be some sort of harm. Okay. So I'm gonna play the court hearing with regards to this corpus delicti. And one is because we want to hear the exchange, so it could provide us with some more information and context. But also, that goddamn Keefie D with his ignorant ass, honey, I was cracking up. He be acting like he be in church and be like, "That's right, that's you understand what I'm saying?" He act like he has no decorum. It's just funny. Keefy D is funny as hell. His mannerisms and stuff, and them gestures and shit, that shit be damn funny. He be moving his head and his whole body, and then he be, and then he cuts it. He cuts a serious case when he be coming up with all this wild shit about what the the guards did and stuff like that, and whatever, told a lot of them damn people. But yeah, so I want to really put that on. I can find it. Okay. That shit was funny. He be in there throwing his head back. He'd be in the same seat. It is just a hot mess to me. Hold on. Here we go. Let's keep it. And what's so funny about this, right, is that for years, right, people was wondering why hadn't he been arrested? Why this, why that, whatever. I stopped paying attention to this a long time ago. Okay. I'm talking about almost as soon as the that Orlando, his nephew, was, rumored or was mentioned as the one that had something to do with the murder. So it was later on, probably within the past, I would say within the past 5 years, where I had, picked back up on it and had seen where there was that, there were people that had came in and spoke to the detectives and things. And well, let me go back a little bit. Prior, where I knew about, because the documentary that came out, or whoever was forming a timeline, telling, with Russell Poole and the other dude. Hey, Gary. Hey, Queen. Russell Poole and the other people. Um, hey, Daniel. Russell Poole and the other. What was the other guys? Those two white detectives. And then you had Frank came out, and a lot of people, and of course I saw those over the years. But the legal part of it, I wasn't paying attention to that, right? I wasn't paying attention to that. So I didn't know there was a proper agreement that was out here. I didn't know that. And oh yeah, and then I saw Keeper D on Blad when he said he had 6 months to live or something like that, or something like that about that cancer or whatever. You know what I'm saying? I promise you. So that was within the 5 years, right? I didn't know he had been doing all that talking, whatever. I'm trying to tell you, when I charge something to the game, I'm gone. Okay, I'm gone. I don't know nothing about it. until somebody tell me about it, until it comes across my radar, right? You know, I don't want to get. Fuck it. I mean, I have to be me. I can't be editing me and thinking somebody gonna come get me. And people be using shit and twisting shit. I'm gonna say what it is, okay? And nobody don't like it. I don't know what to tell you to do, okay? Because but it would tell you. So, um, it was JoJo that kept talking about the damn Keefy D shit, right? I didn't even know Keefy D was. I didn't know. I didn't know. I don't be paying. You understand what I'm saying? I just don't. You know. And I know you kept saying, why wasn't he? Why he ain't been arrested and whatever? And it was the proper agreement. I first heard about it from him and what have you. And I know had explained it, and then why he kept asking why he never was arrested. Shit, the motherfucker got arrested. Oh, what the hell? Oh shit. Oh Lord, yeah. Like when people thought that I done told the people to give R. Kelly 30 years because I said he was gonna get 30 years. Huh? And I said, he gonna get 20 years. The man got 20. It ain't got nothing to do with me. I was just, I mean, that's just, we know how to figure that out if you done went to the people's school. Even though I took another path in law, I mean, damn. But anyway, then the man got arrested. And then sure enough, the proper agreement came up. Like what? And so I don't be checking in. I didn't even know, child, that all this was that, you know what I'm saying? That the people and that is so crazy because he was like came out here on the first. I'm trying to tell you, I saw my man on Vlad. Then didn't think about it no more till JoJo brought it up one time, and then okay, and then next thing you know, they got his ass in the county blue. Hmm? Because he had a proffer agreement, right? Which is not transactional immunity. It's a proffer agreement is use immunity. If you remember that from the YSL case, right? Meaning that what you tell us, we won't use it against you, right? Because your confession and your testimony and things contained within that is evidence. So we won't use that particular evidence. But if there's a piece of independent evidence, it comes from another source, we can use that against you. And also, if you lie, that's different from transactional immunity, aka blanket immunity, right? Meaning, whatever you tell us, and if there's evidence that's produced through that, or whether the independent source or whatever, we're not going to hold you responsible for it unless you lie. Okay? That's the difference. Still no word about the R. Kelly thing. I'm just talking about um, his options, right? Where we are now. Because every so often we go over his options for appeal, options for habeas corpus and stuff. We go over, all of that. We've already went over that extensively. If y'all want to just plug in habeas corpus or appeals or whatever into the search bar and you can pull up a video from that. We need to know what's his options now. Are they still the same? Can some other stuff be done or what have you, right? But that's why I put it in that brief. Okay. And we can do at a later date, especially not today, a later date on a live that goes more into it, right? Because again, with anything, I believe this just me in in integrity, especially when you're talking to others, right? You're giving somebody updates or information. I'm just gonna tell you what it is. Okay. I don't trample on nobody's hope and faith and belief in miracles, and definitely not into the belief in God, because I know I don't relied on it. But I can also tell you the truth about the situation. I tell you what it is. Because that's what a doctor does, right? The doctor don't come out there and tell you, oh, you gon' you gonna live for 50 more years and you got stage 4 cancer. They ain't gonna tell you that, even if they give you an operation. Yeah. So, Queenie, I ain't finna play with you today. So, yeah, we're gonna talk about it, some of the options, and I mean, it is what it is. I don't get into all that BS and nobody. I don't do that. And I definitely don't believe in saying a bunch of shit and talking a bunch of shit and but not doing nothing to make something happen. That just ain't nothing but a bunch of shit. That's just a bunch of shit to me. You understand what I'm saying? So I don't know how that works out. Cause now, I ain't no Bible scholar. But I think they say faith without works is dead. So you got to do the other part of it. You can't just, oh, I'm a hope and believe and you know talk a bunch of stuff. Cause see, I get down to the bottom of it. You know, I like to operate beyond the equal sign, meaning the results. When I add it all up and break it down and break it up or whatever, and then I come out, okay, this is a bunch of bullshit or a bunch of lies, honey. That drives me back to the goddamn conspiracy theories. Oh, baby, I don't went toe to toe with, and it's so, but and also depending on what you study and the classes you take, you do know as far as when it comes down to debates and arguments and things of that nature. Of course, that's in my track and solutions and things of that nature. I had to battle conspiracy theories or people who just need a little bit more convincing. So those are two separate groups of people. Therefore, there is some training for that. Believe it or not, there are methods that they teach you to fight with them goddamn crazy ass people. I say they batshit crazy. Okay? So leave me alone, Quinn. But yeah, I like to get down to it. I ain't finna gas the people, whatever. I'm gonna tell you what it is, and then you could, do whatever. Because there's all different things that could be done, while things may look like nothing could be done. But just bullshitting, it ain't gonna work out. You know, I'm just telling you what it is. So that's why I'm gonna tell you what the options are, and I'm just trying to tell. And I know I've been wrong. But I'm just trying to figure out when I've been wrong. Is that for few, amount of times? But I'm telling you, and a lot of times, if you tell somebody the truth, they know which way to go. They know what to do. I'm not gonna tell you a bunch of bullshit, and you be sitting there waiting on me. Ain't nothing happen. I don't live in a world where people do that. I don't fuck with no bunch of dishonest people. I don't do all of that. That's kind of productive to. And I tell you, when I'm going to do something wrong, whatever, I'm telling you, I'm going to do something. I know it's wrong, and it is what it is. How about that? There ain't no excuses for it. I'm telling you, I plan to do it. Yes, I planned to do it. Was deliberate. Yep, I did it. Okay, I like that, Derry. You got to get uncomfortable to grow. 100%. You can't. And that was that when you deal with the super saved people, they always think they can pray it away or pray it into existence or do it whatever. And that may be true. I don't know. But what I do know that that's not an absolute. Because I've seen a whole bunch of people praying. And they didn't get what they prayed for. And that's not any existence that a higher power doesn't exist. That's just maybe evidence that the higher power has something else in store in mind. You know, that could be evidence like that. No, I don't believe we all are gods. I don't believe that. Though a lot of people do. And to be honest, a lot of stuff I only heard since I encountered you people. I never heard them because I'm in the South. You say something like that in the South, baby, your grandmama, your mama, whatever, have you in a headlock, riding your ass to the ground. What? Because there is one God, right? Or the teacher. I'm gonna go along with that, you know. But I'm just saying that was one of my biggest pet peeve because you done had a lot of them leave up out of here, catch that cancer, and say they're gonna pray it away, they're gonna do natural this and whatever. And I'm like, oh my gosh. I'm gonna tell you what's gonna happen. You is fixing to die. We got two, and I'm not making this up. We got too many examples of that happening. That's what be getting on my nerve with them super save people. You gotta literally knock them out with something to get them to move, to do something. You have to ask them questions like, hey, did a job ever knock on your door? Did the job you pray for just come and just knock on your door? Like, Come on. Like, every time, like, of course we all have connections. I'm not talking about that. I'm talking about one where you have no connections or whatever. It's just crazy to me. And people, oh, it just drive me crazy. Those super sane people that be out there like that, and them conspiracy theories, baby, I be wanting to, I done been to war with them. I done been to war with them. Because they set in their ways, they mindset. Sometimes they be on that, it be a lot going on. I be like, listen, Pumpkin, listen. I'm telling you. We saw, and the biggest example are those with that cancer child. And they think they're gonna keep coming to church on Sundays and all this and whatever. But I'm gonna tell you, um, I don't go into that. That's kind of sad. But you got a lot of them that won't take that what you call that stuff, that dialysis. And you know what I need to know? If anybody, because a lot of times Google don't provide you with the right information. And then you got this, a lot of Google is being powered by AI. It's a lot of stuff. It's a lot of information and answers we're seeking and solutions and stuff. It's being returned by AI. The results, the answers, the solutions are being returned by AI. Now, I don't know if you should trust that 100% unless you have a method to test it, or you have some research or some tests. I'm telling you, that AI shit, a while ago, I talked about AI shit. Somewhere around the time I was talking about how YouTube is doing, I'm telling you, when I be on something be happening. And that's not me being no conspiracy theorist. 'Cause I don't do that. That's me watching that there's a fact, there's a footprints and stuff, shit going on. And I don't know how much trust, the percentage of trust they want us to put in to AI, because like I said, I was looking and I be, I be doing a little research here and there when I'm covering something, whatever. And when I found out that they was using the AI in medicine, I'm like, wait a minute, wait a minute, okay, wait a minute, girl, I'm gonna have to highlight this. Please tell the church. You can pray about it, but also need to put in the work to resolve your own situation from. Thank you. I'm trying to tell you, I be wanting to put them super safe people in the headlock. Them people, listen. Now think about it. I'm already argumentative before I even started dealing with anything where I have to argue or was trained to argue. I'm already argumentative. So I was perfect for my high school debate team. Already argumentative. And my mama told me even prior to that, she said, you sure enough can argue. I've been arguing and debating. I used to give my parents, because they would say, like I remember one year, this was my latest, the I was probably like 16 or 17. I wanted, back in the day, I don't know if anybody remember, but they came out with the TV, the VCR, and the stereo all in one. Y'all remember that? You could get that. I wanted that. It was three big items like that. It was that and two other things I wanted. And so, and at that time, honey, my dad was in college. No, my dad was in his child, maybe first home down there at that penitentiary. hmm So, while he had some money out there on the streets. It's nothing like when you out, right? So I wanted that and two other big items. So we were debating. I was debating with them. They was debating with me. It was like, listen, you can get this, and I was also dual enrolled, and they were paying for my college. Because my dad, I was looking over there at the financial aid people. I'm like, well, what the hell is going on over there? Because I was in the line for pay, and they had a financial, and then people was happy because they was signing for their checks, and I'm like, what the fuck? Why am I paying? And my dad had told me he don't want the white folks in his business, so he gonna pay for these classes. Yeah. And then I got old enough to, and then got that real bill for law and shit like that, and be like, I'm gonna have to get aid, and I'm working, so I don't need y'all approve. You get rid around their ass at some point, child. When you get your own job and your own child and all that shit, you can get aid on your own broke ass, right? Okay, stop playing. But yeah, anyway, and so they was like, Mama, you sure can argue because I was debating. How can I not get this and whatever? And it was, oh yeah, and I know what it was. I wanted the one with the biggest TV in there, and they was like, you can get the one with a smaller TV. And we was just going back and forth, honey. But I won. Yeah. So, but if there is there are several classes where we have to train up our fight back and forth with them conspiracy theorists. It's a hot mess. But yeah, it's a hot mess. You remember there? Okay, you can find them at the thrift store. Well, back then you couldn't find them at the thrift store. That was in the 80s. They were early. Yeah, that was in the 80s, the late 80s. Yeah. I ain't want to hear it. And I'm doing good in two schools. If y'all don't stop playing with your mama, I'm dual enrolled. The fuck? But anyway, let me play this. And Keefy, why they always have Keefy D? Why they always have Keefy D at the end? But his child, this man here cracks me up. But yeah.
All right, that's it for page 10. Does anybody have anything they want called more quickly before we get into Davis? I'm sorry. No, you're okay. All right, let's call page 6, Wayne Davis, C377407. Mr. Davis is present in custody with Mr. Arnold. We have Mr. DiGiacomo appearing for the state. This is on for Mr. Davis's motion.
Wow, I didn't see that. You see those people in there with those shirts and stuff. And that's part of something that I want to speak on when we get to the Mr. Kelly part. And it can really serve as information for anybody that's advocating for someone to receive justice or someone they believe that is experiencing injustice, right? advocacy is paramount and tantamount to one, the overhauling of this legal system, two, getting something done, three, if you think that your application for a pardon should be good enough, you probably need to think again and look at some research. Because one thing about it, right? If the federal government or your state or whatever, and of course, I'm not saying that the feds pardons the the states. No, governors do that. But I'm just saying, if the feds or your state isn't working on an initiative like reform for nonviolent crimes such as drugs or something specific like that, if you have a case that doesn't fall along those lines or whatever what they're looking into overhauling already, then you're going to need a separate type of advocacy, right? One like y'all had going for one point. And again, I'm not on either side, whatever. I'm just telling you what I know. I'm just telling you what I've seen. I'm just telling you some of the things I've been a part of. And when I say that, I'm speaking from my personal or professional experience. I truly mean that, right? Now, obviously, if it was something that I did in the past, the only evidence, if there's any evidence still remaining because it was in the past, but luckily I can usually get some form of receipt. Normally it's a living, breathing one. Okay? So I'm not just saying it without it, it's somewhere on the resume. And you don't have to take my word for it. You can always go and look it up for yourself. But I'm pretty sure those shirts, and I can't even see what it says. If somebody can see it, I don't know. But I'm pretty sure those shirts are representing something. They ain't show up all dressed alike for court today. For just to to be cute. Okay, they something's going on, right? And for Miss Alice, she had Kim Kardashian, right? Miss Alice's situation, it wasn't something that was national, made national news and this, that, and third, whatever. You have to get in front of the right people, the right eyes and whatever. You just can't submit the application and, charge it to the game. Everybody's submitting an application. You know, what is groups like Black Lives Matter, the LGBT, whatever, and you got to be strategic with it, right? When you used to see Black Lives Matter, whatever, who you see somewhere in the crowd? Bunch of people, the LGBT people, what they causes are, because they going where they know the cameras are, where somebody's can listen, where sometimes the causes sometimes intersect or crosses over, or affects more than just one particular group. You know, I'm glad I saw that.
To dismiss. Mr. Arnold, I did see that the state filed its opposition on 115. Did you want to file a written reply, or do you want to proceed with oral argument?
I proceed with oral argument, Your Honor.
Okay, you may proceed.
Thank you, Your Honor. To begin with, let's start with the corpus delicti argument. Basically, the law is clear, Your Honor. The state cannot proceed with a conviction against Mr. Davis solely based on his admissions. And if they don't have any evidence to corroborate those admissions, the case should be dismissed. And it's very clear, we both cited to the same exact case as the Sheriff v. Dada case. And the law is very clear that we cannot have just the confessions, because if you just leave that to the jury is going to just assume guilt because he confessed. And so without the state providing any evidence outside of those confessions, that's a huge problem. It amounts to a legal trial, a trial that won't have the correct result. And so the state is saying that basically we were, we should have done this as a habeas petition. I disagree with that. Here's the reason why. We are not contesting probable cause. What we're contesting is, after all of the evidence has been delivered, there's no corroborating evidence. There's nothing. And then the state also stated that we're just looking for a corpus delicti. You just have to look at the body. If there's a body, there's corpus delicti. And that's just not the rule, Your Honor. There has to be, obviously in this case, a body, but the state has also alleged that this was assisted, promoted by a gang. And so those facts have to be evident. And the only way we have those facts is from Mr. Davis's own mouth. The other participants in this, which I'll talk about in my second argument, are all dead. And so, but for Mr. Davis speaking and giving those statements, there is no corpus delicti in this case. I'll go to argument 2. And that's Mr. Davis's right to a fair trial and due process. The state pointed out the correct standard of review for that, and I don't disagree with that standard. However, the part that we disagree with is whether Mr. Davis is prejudiced or not. They're saying, well, the witnesses that died are going to give speculative, well, it's speculative as to what the witnesses would say. In those cases, yes, that would have been the situation. In this case, it's different. I'll just concentrate on these 4 witnesses, Your Honor. Eric Martin, and just for the court's edification, Eric Martin was the person that supposedly gave the gun. DeAndre Smith, he was in the backseat. Terrence Brown, he was the driver, and Orlando Anderson was alleged to be the actual shooter. Without these 4 co-conspirators being alive, being available at trial, basically, Mr. Davis is completely prejudiced from proceeding. And his defense is he made this all up for profit. These individuals, these co-conspirators, have to exist in an effort to kill Mr. Tupac Shakur. If they're not alive, if Eric didn't give him the gun, if DeAndre wasn't the driver, if Orlando didn't shoot, we don't have a murder according to the state's theory, which is following, again, solely the admissions. So we go back to, when was this information available to the state? I would allege that it was available all the way in 1996. Everybody knew Orlando Anderson was in a fight with Tupac. Well, he wasn't in a fight, he got beat up by Tupac and other members of his gang viciously. He was the #1 suspect right off the bat. There should have been an alert. The police should have been searching for Orlando Anderson, but we always knew where he was because he went back to LA. They could have been in contact with him. They could have gotten statements from him. They could have gotten statements from Mr. Davis. They could have gotten statements from Mr. Martin. They knew all of these players way back in 1996. I don't know what happened. I'm sure Mr. Giacomo doesn't know what happened in regards to why the district attorney's office did not proceed with prosecution or at least an investigation at that time. But it's a tactical delay that goes severely against my client because now all of these players are dead. I'll fast forward all the way to 2009. In 2009, the Metro officer comes down to LA and gives us, Mr. Davis gives the statement. That statement, all of the elements of this murder and what the state will attempt to prove at trial if the trial goes forward is what Mr. Davis had said. They had that information. They did no investigation. At that time, Eric Martin was still alive, and also Terrence Brown was still alive. Orlando had passed in 1999, and I think DeAndre Smith in 2005. But at least two major players in this co-conspiracy are passed. The DA's office, again, does not do any investigation beyond that. And so with that, we feel that my client's sufficiently prejudiced beyond repair. It leads me back to the immunity argument. In 2009, I counted, well, I'll just go through the pages, Your Honor. In that 2009 discussion with the Las Vegas Metro Police Department's officer, Detective Long, on page 3, he says, no intent of arresting Keefie. Page 11, I'm not here to arrest you. I'm not here to arrest you. I'm not going to arrest you. Page 12, you're free to leave. I'm not going to arrest you. You can go wherever you want. Page 103 and number 4, Terrence Brown was still alive, and the detective said, I was not going to arrest him. Page 134, I want to close the Tupac case. Page 138, this is confidential and covered, and you cannot be charged on it. Basically, you have the state was given the information by the LAPD. The LAPD had a immunity agreement with him out of the 2008 confession. The 2009 confession came by a product of Detective Dupree. Detective Dupree set that up. The only reason he set that up and why my client would have agreed to was that everybody was on the same page, that immunity was going to be provided. If it wasn't, how come he wasn't arrested right then and there? Because he said, I got the gun from Zip Martin. We were in a white Cadillac. I handed it to the back seat, and then Orlando took the gun and shot Tupac. All of that information is back there in 2009. But again, the DA office, and again, it's not these players, it's not Mr. Wolfson or Mr. Giacomo. That decision was made back then not to proceed with the trial. And now it's the state's burden, we believe, to show why they did not go forward and prosecute. They just can't sit here and say, well, he kept talking about it. No, you had that information in the beginning. You should have arrested him back in 2009. And so it had to be for a tactical advantage. That being, everybody's dead. It leaves Mr. Davis on the hook, and then he can't answer for all of the statements he made after that, other than it was for profit. And so,
regarding the timeline that you've laid out.
Yes, Your Honor.
Would Mr. Martin and Mr. Brown have been alive after the Compton Street Legend book was published, or no?
What is that, 2018, right?
2019, no, Terrence Brown dies, I believe, in 2015, and Zip Martin, I don't recall exactly when he died.
But it's not your argument that he ultimately would, if that's the state's triggering event for starting to investigate, that he would not have been lied at that time. Is that accurate?
After the book, right, when the book was published.
Yeah.
But after the 2009, he was still alive.
Of course, the Detective Long interview, of course, they're still
Right.
alive, but except for Mr. Anderson and Mr. Smith. Okay. I just wanted to make sure I had it.
Yep. And outside of any other questions, Your Honor, I would submit.
Okay, thank you, Mr. Arnold. Mr. DiGiacomo, anything you want to add?
Just briefly, as it relates first to corpus delicti, that's death by criminal agency. Obviously, Mr. Shakur didn't shoot himself, so that is satisfied in a homicide by proof of the facts and circumstances, which were testified to, by the way, at the grand jury. And it is an argument. We didn't go through all of the evidence that is potentially out there. Their argument is there was insufficient evidence presented at the grand jury in order for them to be held under the corpus delicti rule. Even if you were to take it a next step further and say you have to have some evidence of a conspiracy independent of the bullets in Mr. Shakur, there's clearly at least a driver and a shooter, so evidence of a conspiracy exists. And so therefore, corpus delicti is satisfied no matter how you look at it, one way or the other. I also would dispute there's no independent evidence to corroborate, but that's not relevant in a corpus delicti argument. Corpus delicti is about criminal agency, and there is clearly criminal agency in this particular case. As it relates to the second argument, I'm unclear exactly what their argument is on the tactical decision we made. Their argument is he fully confessed, which as the court reviews that transcript, you can tell that he is being a knowing spectator all the way up until Dan Long gets kicked out of the room. Then his lawyer and Detective Dupree have a conversation where his lawyer tells him, hey, if you say the wrong thing, this guy can arrest you. And as you well know, because they're in California, Dan Long can't arrest him. Dan Long has to come back here, submit a warrant for his arrest, and take him into custody. Detective Long never tells him that he has immunity, but even if he did, all that would go to is the admissibility of the statement, because Detective Long doesn't have the authority to issue that, nor do the LA DAs or the LAPD or the federal government. Only a court in the state of Nevada could say Mr. Davis has immunity from the crime of murder in the state of Nevada. And he has pointed to zero evidence whatsoever of any immunity. He has referenced some proffer agreements that he had with other agencies, and certainly that could be the subject of future litigation as to which of those statements are admissible or not admissible. And then the other, I guess, argument is somehow we waited intentionally so everyone else would be dead to charge Mr. Davis with a crime. No, Mr. Davis chose upon himself to publicly confess to a crime multiple times. And that's the evidence that spurred the investigation of Detective Mogg and ultimately resulted in his arrest. Mr. Davis has no basis to complain that he's sitting in that box right now, because Mr. Davis got up there and then even quote once said, I think it's in May of 23 on video, I beat the streets, I beat the feds, and I beat cancer. That was his choice to make. And when he made that choice, the state of Nevada chose to charge him, and he needs to stand trial for the charges, and I'll submit it.
Mr. Arnold, any follow-up?
Just a quick rebuttal. I don't want the court to get hooked up on this corpus delicti. The corpus delicti rule is basically, again, that's in the preliminary hearing stages of the case. The black letter law is this. The law states you cannot have a conviction based upon just his admissions and statements. That's the law. If the state at this point puts on a trial to a jury and that's all they have is his admissions, that whole trial is illegal. That's a legal trial. It's going up for appeal. It should not happen. They need to have something else, a gun, a witness, something else that puts this gentleman, those three co-conspirators in the car. They need to have a witness to say that the gun was given to from Mr. Martin to Mr. Davis. They don't have anything. They don't have anything to even prove that my client was in the state of Nevada at the time of this incident. I mean, basically, they have Orlando Anderson, but we don't know if the Crips were here. That's all hearsay that came from the grand jury, and there is no evidence whatsoever. And so without that, we can't put on the trial, Your Honor. We just simply can't. In regards to the delay, again, I don't blame this office, this DA's office in regards to the delay, but somebody made the decision along the way that we are not going to prosecute Mr. Davis. And this office now needs to go forward with that immunity agreement. They need to. Those promises were made by their officer, the state's officer, and now we're just gonna ignore that? That doesn't make sense.
Immunity agreement from this office, or from the general.
From the general immunity that
yes.
started from 2008 and went to 2009. Like I said, the only reason that,
Who
2000
within Clark County DA's office made that argument? Was that,
no, it wasn't at the DA's office, it was the Las Vegas Metropolitan Police Officer, Detective Long.
when he said things like, I'm not going to arrest you?
Right, right. And again, like I said, it was not the office. And so outside of us, having an evidentiary hearing as to who made those decisions back then in the DA's office, I mean, my client is just prejudiced because of those decisions. Because again, everybody waited all these years, and now we have players that are co-conspirators that are just dead and can't, deny participation. And so with that, we submit, Your Honor.
Thank you so much, Mr. Orno. Okay, I'm going to take your arguments in turn. First, the corpus delicti argument. I am going to consider this on its merits, given the Supreme Court's guidance in Diami versus State. I think it's better to at least hear it on its merits. Corpus delicti requires that there be corroborating evidence to support a confession. In a homicide case in the Nevada Supreme Court, as you both said, indicated this would be satisfied by proof of death by criminal agency. So I think maybe an example makes the most sense to explain what this concept means. For example, I confess that this morning, as I was driving into work, I killed someone on 3rd and Lewis Avenue. All right, now let's say there's no body ever found, there's no video, there's nothing. It's only my statement that I killed someone that makes this crime exist. However, here, that is not, in this case, that isn't the case. There is corpus delicti because Mr. Shakur was shot and eventually passed away from his injury. An autopsy was completed. His death was determined to be homicide by gunshot wound. And ultimately, it's a situation where the crime has been established. That the murder occurred because of the body of Mr. Shakur. So I will deny it on those grounds. Regarding the pre-indictment delay argument, as you both cited, it looks like the standard that's laid out federally in People versus Nelson. I'll use that standard. A delay in prosecution that occurs before the accused is arrested or the complaint is filed. So we're looking at a pre-indictment delay argument. That could potentially constitute a denial of the right to a fair trial and due process of law under both state and federal constitutions. And then determining whether prejudice to the defendant has occurred, the court needs to balance the harm to the defendant against the justification for the delay. Here, it's clear that some of the witnesses are now deceased, and there is definitely evidence that has been lost. However, I do find there is a justification for the delay, and a pretty significant one. Uncovering information on Mr. Shakur's murder was ultimately no easy task. There was the interview in 2009, but it's clear that there was, at the attorney's suggestion, Mr. Davis at that time was not giving full information. He was sort of trying to obscure information and make it very general so that he would not be charged with murder, as his attorney indicated. It was not until ultimately the Constant Street Legend book was released in 2019 that Detective Long then sought to establish the words in the book are actually defendants and to corroborate these things. The prejudice of the death of those 4 victims that have been identified had already occurred at that time. Additionally, it took the next several years to gather that evidence and ultimately led to the June 23rd, 2023 search warrant of the defendant's residence. After that search warrant was executed, then the grand jury indicted the defendant after several meetings in September of 2023. The defendant has not provided any evidence to establish the delay was intentionally done to gain a tactical advantage or that the prosecution delayed in bad faith. I don't see that the state really does gain any sort of tactical advantage here. I still think it's a bit of an uphill battle for them given what they have. And and ultimately they can't get complete justice for Mr. Shakur because of the deaths of those other people, including Mr. Anderson, who's the alleged shooter in this incident. And so I ultimately don't see that this is a situation where the state really got any advantage by delaying, and in fact is themselves hindered. And so overall, I'm going to deny on the pre-indictment delay argument and turn to the immunity argument. It's fairly clear that the state of Nevada has never offered the defendant any sort of immunity. The federal government did in some capacity, but it doesn't appear to be complete transactional immunity. The court agrees that the interview defendant gave to the federal authorities in 1998 cannot be used against him as per the terms of the agreement. I think that's something that the state also conceded in their motion. However, the defendant has not produced any sort of agreement showing the federal government offered him transactional immunity from ever being prosecuted for this crime. In the 2009 interview that's been referenced multiple times throughout these arguments, Detective Long's assurances of not arresting Mr. Davis really go to whether he was in custody for purposes of Miranda or things like that. Additionally, he didn't have a warrant at the time, so that was an accurate statement of the law. There's nothing in that that can imply transactional immunity. Additionally, the defendant's attorneys at that time of that 2009 interview with Detective Long kind of show the opposite conclusion, that he is concerned with the defendant being charged with murdering Mr. Shakur, and that which leads me to believe that Mr. Davis did not have transactional immunity in the view of his attorney, and that's why his attorney advised Mr. Davis to keep it vague. And at that time, Mr. Davis did listen to his attorney, but his subsequent interviews and his self-proclaimed biography did not keep it vague. As the years passed, Mr. Davis revealed additional information on his own volition, and presumably for his own pecuniary interests that connected him to this, the alleged death, or the death of Mr. Shakur, allegedly at Mr. Davis's hands. And I do find the state is entitled to use that information freely given by defendant with no prompting by governmental authority and released to the public in its prosecution. So I'm going to deny the motion on those grounds. Overall, the motion to dismiss is denied, and the state is prepared the order consistent with this ruling and with its opposition.
Thank you, we will.
All right, regarding trial readiness, where are we at with that, Mr.
Can we approach her?
Of course, yes.
Give me 1 second to go off on
We'll lose.
Trial readiness, Mr. Arnold indicated that Arnold, I'll give him an opportunity to do that if you need to recall. All right, Mr. Davis does want to speak to Mr. Arnold. I'll give him an opportunity to do that if you need to recall. Please let me know, Mr. Arnold. However, regarding trial readiness, Mr. Arnold indicated that there were potentially some issues that could prevent this case from going forward on 3/17. I'm going to hear those issues further on 2/11.
All right,
So we'll see everyone back 2/11 at 9 a.m. for status check trial readiness.
all right, thank you.
Thank you.
All right, thank you.
Would it be okay if we call? I got something to say. They're not only ugly on the outside, but they're ugly on the inside.
Dwayne Keefie D. Davis, the man accused of one of the most infamous murders in recent history, spoke out during a court hearing Tuesday, accusing the government of tampering with evidence in the Tupac Shakur case. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. It's been a while since we've talked about Dwayne Keefie D. Davis, the notorious purported gang leader accused of ordering a hit on 90s rap superstar Tupac Shakur, who was gunned down in Las Vegas back in 1996. The 61-year-old was back in court this week to argue that he should be out of jail on bail, on house arrest instead, as he awaits trial. Now, even though he is facing a charge of murder with the use of a deadly weapon and he has pleaded not guilty, he allegedly admitted his involvement in the killing in interviews and has claimed he was one of 4 people in a white Cadillac that pulled up to a BMW that Shakur was in when the gunshots rang out in Las Vegas. Now, Davis allegedly claimed that his nephew, Orlando Anderson, who's now deceased, was the one who actually shot the rapper, although there is reporting that Davis was the one who maybe provided the gun. Again, these are allegations at this point. But what we do know is that Davis has become the only person ever charged in the shooting of Tupac Shakur. He's being held in Clark County since his arrest last September. And now we've learned that prosecutors seem to have new evidence that they say proves Davis was in Las Vegas on the night of the killing. They say a hotel room was booked under Davis's wife's name, The state also says a witness, Corey Edwards, provided a statement to police in 2006 that he saw Davis with his own eyes out in Las Vegas that night. This was after the Mike Tyson fight. In a legal response, a footnote reads, quote, "Unlike many other witnesses who have provided corroboration of defendant's guilt, Mr. Edwards is still alive." Now, Davis's attorney has previously said that just because Davis says he was in Las Vegas doesn't mean he really was. One of the last times the issue of bail came up was back in June, when Davis explained that he could put up the $750,000 bond. Here's the problem with that. It seems Davis's team has pushed for someone in particular, someone in the hip hop community, to put up $112,500 of the bond premium. Reportedly, this is coming from entertainment manager Cash Whack 100 Jones. And the judge in this case, Clark County District Court Judge Carly Kearney, had reservations about whether the source of this money was actually legitimate. So
Okay. We saw that before, right? And I was trying to find his indictment because I think I have it on my other computer, but some techie person, I told you I got a house full, and some techie person thought that I should hook up my equipment that I've had just in boxes for years, and so and that's what I'm on. That's why that when I play the music, it's of a different quality because I'm playing it from my phone and not what I usually play it from. But I'll get that back hooked up. Honey, that guy there, Keefie D, be sitting up there with that big old ass head, and he thought he had no score on. He was like, yeah, he done nod his head and shit, man. I'm like, oh my gosh. So I kind of explained to you what they went ahead and went over in more detail about the corpus delicti and the what it really means and what it requires, right? Of both sides, right? What one side is saying, it's saying that hey, well, you can convict me, you need to have evidence that a crime occurred. And I either forgot or it definitely wasn't on my mind for tonight that I don't know if he is convicted. I'm sorry, he's been charged. He's been charged for conspiracy as well. Must be. I don't think he's been charged for just for the murder. Maybe it's conspiracy to um, to carry out a murder, what have you. I'm not sure, but I need to get a hold of that indictment, and I want to see if I could find it real quick online. But I just think I don't know what I found, but it says indictment, but I don't recall it looking like that. The last one I've seen, and I found some other stuff, but the state was also correct. You sure enough did. Hold on. See that baby, them other information specialists, they be, oh my god. I ain't gonna complain about it, but child. Hold on. Let me see what I got. Okay, that's the bill. I got the bail. What is this? Now this computer here whew, got a memory, honey. I'll never run out of memory with this one. I have bail, but I don't. Okay. Hold on. I'm sorry, y'all. Why is not coming up? Okay. And that's the hearing. That's the bail order. What's this? Ooh. What is this? I'm coming, y'all. Y'all gotta understand, honey. My girl's a bad girl. She sent me a hook. I don't see the motion. I mean, not the motion, the indictment. I see these people business though. Hey, I see all these people. Um, background information. Mm. Ooh, it's the bail. I don't see the indictment. What's this? Yeah, all this is the bail. But I think I can use. Hold on. I think I can use this that I'm getting off of. What up, Lavelle? I got to make sure I get. Okay, thank you, Punkin. I got to make sure. Girl, right, right. I got to make sure. Um, something. But anyway, so listen, Lavelle. Oh, let me make you laugh. Oh, I know what I was going to say. I got to make sure that when I add you, that I'm using the right Lavelle Marshall. Lavelle, how about this for him? Don't say nothing. Don't say nothing. I'm gonna tell you right now. Shut up, Lavelle. How about I was trying to delete Amazon, the Amazon app off the Fire Stick. Shut up, Lavelle. Don't say shit. Don't say nothing. Hey, I was trying to get my tech on. I've been trying to get my little tech on, here and there. Right? I'm trying to get organized from a new job and all that, whatever, and trying to, get my stuff together. And I got another Fire Stick. I'm just trying to get all my tech shit together because I ran out of space with that other one of the fire sticks I had, one of them $30 ones, right? So I got one for the $50, with the most memory on there. So I can, and I said, I don't want the apps that I don't need on my fire stick. I don't want, because I need my, what I need my fire stick for. And I'm sitting up here getting mad. I said, well, damn, why I don't give you no option to delete Amazon off the fire stick? Lavelle, 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 listen, I ain't the smartest, baby. I said, damn, it was so many Lavelle Marshalls in there. I was like, damn, Lavelle get a kick out of this one. Boy, I hollered. And I sat there and thought, I'm like, you a dumbass. Shit. I was like, shut up, Lavelle. That's when I was trying to include you in the thing. I was like, shut up, Lavelle. Shit. Don't say nothing. Hey, it's hard out here for a dumbass. Don't even say nothing. Oh my God. Queen, you got it too. This nigga from Amazon and a hard drive. Get a dongle from Amazon, add a hard drive to the fire stick. Listen. Okay. I'm telling you, Lavelle, it better not be nothing where it's too damn complicated. Mom's sitting up there trying to delete Amazon. I'm like, it ain't give me no God. I've been trying to do this for months. I tried to delete it from the other one, try to create some memory. I was getting, I go to, and I've done some with the Google, the Chrome, and that's a new one too, and that has a lot of memory. It's just showing Google and they take me to where I need to go. I'm like, ooh, but I was sitting up there like, shit. I'm trying to get me some a memory, and once you use up all the memory, whatever, some of them things will block you where you can't even get to know where to delete it. So before you do all of that, shut up, Lavelle. Listen, Lavelle, let me tell you something, Pumpkin. Pumpkin. Your mom would been on the grind, honey. I've been trying to get my legal shit on. I'm sitting up there trying to figure out how to program. I'm all in the cars now, baby. I'm trying to program a key fob, the key fob back to one of the cars and shit. Okay, I done looked all over Amazon for what I need, the little machine. Now I don't want to go buy that machine, but it's cheaper to just go take it somewhere or whatever. I don't want to have nobody no $300-$400 and all of that to reprogram no goddamn key fob to no goddamn car. Cause if you don't have the damn key fob, that I've been on my shit. The little thing up under the handle and all of that, whatever. I don't know what's going on. I don't know what's going on. You understand what I'm saying? I don't know what the hell is going on. And a lot of things, when it's stuff like that, that's a my bill. When I'm doing all kind of shit like that, and especially when I mess it up, that's a me bill. It's unfair. I'm fair now. I know y'all don't think I'm fair. Okay. Yeah, I don't do no 50-50 and none of that type of shit. So obviously when I'm nice and whatever. I fuck it up or whatever, I'm gonna come out my pocket. I'm just trying to see, since I'm on my tech shit, can I program a key fob? I done call all around to the Nissan places and stuff like that. Like, ma'am, bring it. You ought to bring it in. No, I did. I'm way ahead of you, Lavelle. They gave me those instructions about going to AutoZone, whatever. They don't do my car. I don't even went there. Bring it in, ma'am. Hey, that what they said. Bring it in, ma'am. And bring your checkbook with you. And I'm like, if I go get the machine to do the key fobs, ha. Oh, if I get the machine to do the key fob, I might can go into business doing the goddamn key fobs for people for cheaper than what I've been finding. Oh, I gotta look into that. Wait a minute, let me write that down. Buy key fob machine for real and go into business. Y'all also know this, right? Y'all also know that you can get by certain apparatus like that or whatever, or things like that, and hire people to do the jobs for you. Y'all do know that, right? Baby, listen, I'm a bona fide hustler, side hustler. Yeah, you did your key fob and all that for $79. Oh, I ain't getting none of them prices about no $79. I ain't getting none of that. None of that. I need the machine, little tablet looking machine. You need that. And and I don't understand the language on the different little keypad machines, because I don't know if it's going to allow me to program my card with that. But anyway, that little button up under the handle, I didn't even know it was a button up under the handle. I often wondered, well, damn, if you can't get your damn um like like uh, how you gonna get in there to crank up the car? If you lock that door, you can't get in there to push the start. You can't get in there to do shit. Understand that? It's a gimmick, baby. For I was trying to get around it. You know, I was like, well, shit, I ain't trying to get nobody no for them to. Okay, thank you. To save the programming for your car catches that you can only do 4 keys. Okay, when you say keys, you mean key fobs, right? I don't need no key. And that button up on the door, you push that. That ain't unlocking no damn door. They ain't done nothing. It's a bunch of bullshit. That's what I'm trying to tell you. That button ain't doing nothing. Hold on. Okay, I keep up. It make a key. Yeah. Because I was calling, telling my child to go out there and mess around with the damn thing. And I was telling her, well, do this. It say do this. It say do this. It say do this. And none of that shit worked. I'm like, oh. But anyway. But yeah, oh my gosh. But y'all, so I'm serious, y'all. Just don't buy. I'm trying to tell y'all right now. Y'all trying to y'all get your little fire stick. Don't even worry about Well, a lot of y'all don't even be doing all them channels and stuff like that, like I do. So probably, the little $30 fire stick will work for y'all. It don't work for me. I need the big one, the new one, and that way. And I tried to. I learned, but I guess I wasn't paying attention. I wasn't paying attention to the damn fire stick. But normally, when I buy stuff, I learned the hard way years ago. Just go and get you the your device with the most memory or whatever you can, because it's gonna run out. And let me tell you this right here. Go ahead and slap the person who said that you'll never use 1 terabyte. I'm here to tell you that's a lie too. That's a lie. So I be getting 2 terabytes, like the little things with the memory and stuff, whatever. If it gives me an option where I can buy 2 terabytes, that's what I buy. That's what I pay for every month on that iCloud one, and that is that Apple, the 2 terabytes. Yeah, I can't. Uh-uh. But anyway, so back to old Keefie, Lord, and let me put up. Hold on. Okay, got it. Okay, that's the same one. Okay, let me. Thank you, ma'am. So we need to get. I need to get better with, like, when you cover this stuff, provide the updates and stuff. Mhm. Okay. And it's some of this stuff does tie into Puppy. Like this is crazy. They getting them all off the street, honey. Okay. This is the Keefie D indictment. Okay. It says the defendant above named, Dwayne Keith Davis, accused by the Clark County grand jury of the crimes of murder with the use of a deadly weapon with the intent to promote, further, or assist a criminal gang, category A felony, committed at and within the county of Clark, state of Nevada, or about the 7th day of September 1996, as follows: did willfully, unlawfully, feloniously, and knowingly, for the benefit of, at the direction of, or in affiliation with a criminal gang to which Southside Compton Crips, which had as one of its common activities engaging in felonious criminal activities other than the conduct which constitutes the primary offense and the defendant with specific intent to promote, further, or assist the activities of the Southside Crooks gang with malice aforethought, killed Tupac Amaru Shakur, a human being, with the use of a deadly weapon, to wit a firearm, by shooting at and or into the body of the said Tupac Amaru Shakur. Said killing have been willful, deliberate, and premeditated, the defendant being criminally liable under one or more of the following principles of criminal liability, to wit: one, by directly committing this crime, and or two, by aiding or abetting in the commission of this crime with the intent that this crime be committed, by counseling, encouraging, hiring, commanding, inducing, and or otherwise procuring the other to commit the crime, to wit, defendant obtaining a firearm for the purpose of seeking retribution against Tupac Amaru Shakur and or Marion Knight, aka Suge, and while in a vehicle with Terrence Brown, aka Bubble Up, and or DeAndre Smith, aka Big Dre, and or Orlando Anderson, aka Baby Lane, did provide said firearm to DeAndre Smith, aka Big Dre, and or Orlando Anderson, aka Baby Lane, with the intent that said co-conspirators commit said crime, and or three, pursuant to a conspiracy to commit this crime with the intent that this crime be committed, defendant and or Orlando Anderson, aka Baby Lane, and or DeAndre Smith, aka Big Dre, and or Terrence Brown, aka Bubble Up, aiding or abetting and or conspiring by acting in concert thereof, of the route. I'm sorry. So there is that conspiratorial element in what he's been charged with. So the state is correct. That does meet um, the state requirements to with regards to the corpus delicti, right? There were more than one person involved. So that conspiratorial element is there, as outlined in that indictment that I just read. So, um, and I also, in listening to that court proceeding, the defense stated that they were told that it, they should have filed a habeas corpus. Okay, now some people think that a habeas is only filed post conviction, right? And I explained when I was explaining habeas corpus a year or so ago that you can file it before a trial as well. Just can't file it during a trial. Well, it's not typically allowed. And let me say, a lot of things in law aren't absolutes, right? So I shouldn't say that, but that's normally how it goes, right? You can file it before, you can file it after, because what it deals with is someone being held unlawfully. Okay, someone being convicted unlawfully, right? Because they were held unlawfully, or because some legal errors occurred, you know, something of that matter, something that affected or that would affect their substantive rights, right? And we know when I say substantive law, that deals with someone's rights and obligations under the law, right? What you can and cannot do, which procedural deals with how those rights are governed through the um, through the through the, through your trial and your review process and all of that, right? So, somebody need to give me. Does anybody have the information for hot flashes and shit? Cause I can't deal with this. Somebody said you go through this forever. But so I don't know. I stopped because I was trying to figure out what was the reason that his attorney filed a corpus delicti in this manner, right? Because I told you exactly what it meant. We do know that Tupac is dead. He died because he was shot. Okay. So there is evidence that a crime was committed. And so I don't understand. And the process is going to play out just like when everyone else accused of committing a crime. Someone is going to either determine that you did it or you didn't do it. Oh, wow. Oh, girl. I put a lot of the information on that paternity case on the wall because that is a books from several people. That's just books of information. But I put out the fact that, okay, I'll get to that. We're gonna get to that. I can double back and get to that. But let me close this up a little bit. So anyway, and the the state is right. There is criminal agency, meaning that you know Keefie D made choices and he had control. That deals with criminal agency. So what we know about the corpus delicti is that, again, it is to prevent someone from being wrongfully convicted due to a what? Confession. Most states require that you have an independent piece of evidence outside of the confession. We know that the state has to prove that a crime did occur. And you can definitely do that when you have a dead body full of bullets or a body that would in 6 days. Or, and I'm not critiquing attorneys or what have you, because again, right? And if you heard him, he said, "Hold on, y'all, we getting caught up on the corpus delicti. You the one filed it. What you mean you getting caught up on it? You the one filed it. That's why you have to. They have to address it. They have to address it because you the one filed it. Like, come on." And I think he probably didn't go the habeas route because now you're dealing with, and that's a heavy motion, right? Because now you're saying that some rights was being violated. You're dealing with the constitutionality portion of it. And that can go via the substantive route or the procedural right? Legal errors. That's what you're saying. So, and a lot, I guess maybe he didn't want to mess with it, maybe because if that can be a tool used if he's convicted. Excuse me, that can be a tool used, one time, and he can, include if any legal errors occur during the trial, then he can use it then. So I mean, I don't know really why. I mean, but you gotta. Hey, quit. Huh? Scam you? Or somebody trying to scam? Hey, but listen, when I had you out there trying to program that key fob thing or whatever, that button up under the handle, did that unlock or unlock the doors if you pushed it in? Okay, it didn't. Okay, that's what I thought. Okay, all right. So, but yeah, she said it didn't unlock or do nothing. I don't know, but so okay. Now, when he said the grand jury transcript, the two people told on him. Oh Lord. And he also stated in his book and interviews that he told them that they had to go get. Oh, okay. But yeah, so Keefy D put his own self in that seat by doing all that talking. And probably to his own ignorance, and I'm pretty sure his attorney explained it to him, and I know they explained to him what type of immunity he has and the particulars that do it's not blanket or transactional immunity as they referenced in that piece we watched, right? So I don't know why in the hell he sat up there and did all that talking. He said it was for profit. It seemed like to me he could have found another way to um, exploit that rather than uh, confessing to. I really don't really know all that he said and confessed to or whatever, but what I do know that it seemed like to me he probably could have kept it consistent to what you had already told the people. Like, stop trying to do too much. I mean, yeah, you know, I mean they are going. we see people like him and Jaguar and Gene and a lot of these favorites that keep showing up on with these interviews and stuff, and they are doing the most. They're doing the most for a couple of dollars. And now look at you. Because of your actions. So, yeah, he thought it was safe with. Yeah, I saw that. I just downloaded again on this computer. I don't know. And it was some other transcripts that I just came across here. Oh, this was in 20. Yeah, this was since he's been in jail, these transcripts. Yeah, poor Keefie D. And everybody trying to get out. Everybody trying to get out on bail. So I don't know. So I have that. Let me see. Is that all I have for Keefie? Just wanna update us on Keefie. I did good too. I wrote down um my stuff on Mr. Keefie. Stuff I need to talk about. I want to make sure I'm listening. Mm, 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 mm. Yeah. So um this is an example of a defense, and I'll say this is true of, and this is my opinion of this situation. Keep it D. Of the pup situation when we move on to that, because I'm getting ready to talk about that, and I can slide ASAP in there, even though it resumes tomorrow. Hopefully, I'll be done. The thing about it is, I have to wake up in enough time so I can be done in enough time to start ASAP on time, right? Because I'm technically, um, I mean, I can technically just start tonight, and but don't worry about my schedule, whatever. But my thing is, um, just doing it, doing something day by day, and the requirements are a little different at this school for um, adjunct and online professor, so it's a little different. But anyway, the the truth can be said, but even when it comes to Mr. Kelly with these attorneys, right? And I'm not by any means saying all hope is lost, blah blah blah. I'm not saying none of that, right? But with these attorneys, they have to get a little creative. They have to make a play on words in the law. They got a lot going on, so it's not going to be something that is easy, right? It's not going to be cut and dry. I mean, this dude came up with corpus delicti, and I told you. I mean, there's a dead body with, and even the judge is pretty much saying what I just said. Said what I just said. There's a dead body with it, so she know it's satisfied. The corpus delicti is satisfied. I'm trying to understand. I'm trying to get it together. Trying to figure out. Yeah, but you got to find a route to go when you are trying to free your client, right? You're trying to get them bail or something. you're gonna have to pull little tricks, little games. Get a little creative with the pencil, right? Okay, you're gonna have to do that. And that's what they get paid for. So I don't want none of that smoke like that. One, I'm too leisurely. Okay, I don't want to be doing all of that. Even though I like to think or whatever, I don't want to be put up on the gun about something that I got to think the hell on. I gotta think it on. I want to think about what I want to think about, how I want to think about it. If somebody's life on the line, I don't want to do all of that. I'm just trying to tell you. If anybody want to go to law school, you want to duck that smoke. Transactional law is it. No, don't be doing all. You ain't got to do all of this. You ain't got to appear nowhere. Okay, really, depending on who you work for and how you do it. So yeah, but this is what they have to do. Um, as you saw, and I'm not jumping to Mr. Kelly yet, but I'm saying, but just an example for you saw Jennifer Bonjean try to attack the Protect Act with um, who she tried to attack? Was it with the Supreme Court? I think. Yeah, that was her filing with them, her brief with them. That's a whole act, and she wanted them to interpret what exactly they meant. That's what you got to do. And I know when I see lawyers making these attempts, I know what that means. It doesn't mean that all is lost. It just means that, it's kind of like a Hail Mary. They're going that route for a reason. Because if there were any more routes that could have been taken, they would have taken those. Because there are some routes that it is almost clear and convincing on paper that there is some sort of you get the Constitution violation is pretty clear, or you understand what I'm saying, when you got to rely on an interpretation and a play on words and all of this, as that example I just showed you, that's pretty much what that attorney is relying on, because the law is pretty clear on that procedure, the rules, and what each side must show. So, and by any means, I already said, you know, I never tell nobody to give up hope, faith, rely on miracles in God. I'm not. We all do that, but we also know that the results isn't always what we want, what we pray for, right? So I'm just saying, you got to find other routes, other, you know, explore them all. That's all I'm saying, and nothing wrong with that. So while I agree with the attorney exploiting them all, um, I just think that some routes are going to be, they're going to be able to poke holes in it. Just as clear, that judge was like plain and clear, like, okay, but we got evidence of a crime. It's not even that evidence of a crime that he committed it. That's not the standard. That's not It's evidence of a crime. You understand what I'm saying? If I punch you in the face, That's evidence of a crime. You know? So, and then he tried to back step off his own shit and say, wait a minute, don't get caught up on the corpus delicti, huh? And then as you see the state, all he doing is pacing and shit like that, right? Pacing and stuff like that. It's especially when you are the prosecutor or whatever, you about to like, what the fuck, in the courtroom. But yeah, so moving on. Let's get on that old. They, oh yeah, they getting paid 5 to 10. Oh yeah, yeah, they getting paid that to get on them damn interviews and stuff. That's yeah. Them 20 and them 20 and versus one are they getting paid for that stuff. Cause you look at the numbers on those channels, those people can afford it. One thing about when you deal with media and advertising and all that type of stuff, you are doing one thing, right? But you're making money several different ways. You understand what I'm saying? Those channels with that much volume and all of that, they make a nice. Then they got sponsors and all of that, right? But in order to get the sponsors, you got to grow your audience, and you got to, so they get that. You understand what I'm saying? That's the advertise. Then you get the with the sponsors. Then you got then with that, and then a lot of them they got selling something on with that content creator, and then that's when you see those advertising codes. So that there go another branch of that particular, that you got. It's crazy. It's just that tree, how I would draw that or whatever, that tree be so goddamn like it's all over, it's just flourishing, right? It's just, several different branches coming out of that tree. We, in this sector, whatever, probably never get, let me see, probably just channel alone, probably never get $1,000 check a month, to be honest. How? And even with cash apps and stuff like that, you ain't gonna get no $1,000 a month. Cash and then that's money that you are dependent upon somebody else. So that's not regular. You know how much, like, you ain't gonna get that. How? YouTube pays little pennies, like 1 or 2 pennies on a video. That's not a day. Uh-uh. That's 1 or 2 pennies for that cutoff period. Like what? You're not gonna get that. You ain't gonna get no $5,000 a month. You ain't gonna get none of that, none of them numbers, nothing. You get a check. Once you get $100, it may take you 3 to 4 to 5 months to get up $100. That is if people have given you some super chats enough people have given you some super chats and shit. I ain't gonna lie to you. I'll show you the printouts. People tell them lies or whatever. Ask for printouts. That's that. I'm talking about at your highest, at your goddamn lowest. It's hard to come on through with $1,000 a month. I'm not making this up. Stop laughing, Queen. I'm not making this up. Just show the printouts. That's simple. $5,000 a month. It's a bunch of people that have. Maybe if you got maybe about 70,000 subscribers, active subscribers and shit. It's probably gonna be you. They got to be. You got to be putting up some super chats, honey. I mean, a good one to ask to see the printouts of. Ask Nyla. You know when she had when before she had her channel shut down, and you know how many subscribers she had, and those people was putting up money because those people wanted their messages read or whatever. Then she had what you call it, memberships. Them people be having memberships activated, ads, people super chat, and them people go live every day or just about. That's how they was getting them checks for $5,000 and shit like that. Yeah, you gotta believe me. Ask what's his name? What his name is? Lead attorney. He'll tell you. He pulls up his graphs and things whatever to tell you. You wait for 5,000 if you want to. So hi Angie. Our content creator paid me $300 this month, but he had over 500 members and get so many views. A content creator. Over 500 members. Yeah, 500 members at that tier, even at the 99 cent tier, 199 tier, a dollar. I'm sorry, a 99 cent tier or $1.99, right? Okay, Miss Frugal, type them numbers. Type what you saying again, because I don't know if you saying. I don't know. I don't understand. Okay, from the you said 300 paid. I don't understand what you're saying. If you got members activated, they've been paying you super chats. If because YouTube is only gonna pay you a couple cents. He paid you $300 just for being a mod. Well, goddamn. Now, what you say his numbers are? 500 members, right? And I don't know what tier it's set at. And how many views you say he get? I'm trying to see, is it 90? Does it start at 99 cents? I think it starts at 99 cents, right? Okay, 99 cents, right? Within 1 hour, he gets over 50,000 views. 50,000 views in 1 hour. See what I'm talking about? That's what I'm saying. You got to get a whole bunch of shit going on. Wait a minute. I'm trying to do some math, honey. You said vertical screening is the way to get views while on YouTube. Right, but the money, that's what I'm trying to explain. The money, we'll never get it down here. We're like that. Shit. The money is in them views, the membership, damn super chats, and all that. That's why when you see leading them or whatever, they're not just saying, okay, ooh, these ads are gonna, give me a nice check or whatever. Yeah, them ads have something to do with them views, right? But then when you got people giving you $99, $50, $5 and $4.99, all of that, every time you go live, right? The ads. That's what I'm trying to say. The ads help, right? But you get the bulk of that money that increase that check when them people come out their pocket, like throughout the membership, they got their super chat, the cash apps, and all of that. When you add in the cash apps and all of that, yeah, I mean, you getting 50,000 views in an hour. Yeah, you can make $5,000 a month. All I'm saying, we'll never do it. That's all I'm putting down here. Okay, that's some crazy ass numbers though. Those are crazy ass numbers. Those are good numbers though. And another thing, people have actively figured out the formula to make all that happen. It's people that's actually studied and is making that happen. I ain't talking about buying no views or none of that. That's empty shit. I'm talking about actual compressions, actual people that's really doing it. Well, one, we don't have the intelligence to do it, and we had the ignorance that just to be beefing and acting like a damn fool and all this, that, and the third, whatever, We just don't have that. Right, that's what I was saying. And I don't know that, but that's what I was just saying. They study that shit. They say, yeah, we don't have the intelligence to do it. We had the ignorance to argue and fight and kill you and do this and dox and all this and talk about your mama and your granddaddy and all that extra shit. And yeah, and hey, a lot of people don't be and it's so oh my god, I told you, illiteracy is going and ignorance is going to kill us all in this world. People think that by beefing and arguing and talking about people and this whatever is how to get that. There's a ceiling on that. That's only going to go so far and last so long. And the only type of people that's going to attract are the same people it keeps attracting. Not no new people, whatever. These people be growing. See, that's the thing. You have to grow your channel if that's what you want to do. In any business, anything that's profitable requires what? Growth in what? All areas. Whether it's people, whether it's product. It's growth. You can't remain stagnant. You can't go down. You can't, People think in their ignorant ass head, ooh, if I start shit, if I talk about some negative shit, ooh, I can, keep people coming, whatever. I'm like, you one lonely ass motherfucker. You ain't got nobody on the phone to call. You can't go knock on nobody's door. They won't let you in. They probably ain't got nothing to talk about. You understand what I'm saying? And here's the thing, right? Negativity sells, right? Now listen to what I'm saying, because I could say this over here, because all y'all, I know y'all degree personnel or degree worthy personnel, so I know y'all can understand what I'm saying. Now, I said all I just said, right? About negativity, whatever, how it doesn't work and you have to, grow and whatever, right? However, there is a area where negativity does sell. Negativity does produce. Negativity does grow. We're just not in that area. That's something different. That is something different. Negativity within medicine can grow your profits. We'll catch that over here. Most of them won't. Okay? Right. Time is money. You understand what I'm saying? Negativity in medicine can produce growth. It does. Negative in the law can produce growth, money. It does. So I'm not contradicting myself. I want to make sure you understand that. And this year, I cannot stay on the remedial track. I can't do that. I can't do that. Mm-mm. The remedial track, I can't do that. You have to go somewhere else with that. I can't do that. I can say it once or twice, but then I'm gonna have to go some. I have to be me. Being what somebody else want me to be, or being to somebody else to accommodate, that ain't work for me. That ain't never worked for me. So that remedial shit, I'm trying to tell you that it had me slowing down. Dealing with mediocrity and remedial ass shit, I ain't gonna be able to do that. So understand what I'm saying. Now, when I in the first part, I was talking about here, and YouTube, and this, that, and third, whatever. Depending on what you're talking about, whatever negativity is not going to do nothing for you. If you're talking about profit wise, and if you're talking about, you want to be loved, who want like, what the fuck? Who gonna love negative shit for a long time? No, right? However, there is an arena. There is, a certain area, certain places where negativity does grow, will help you grow, does grow business. Okay. So y'all can tell I'm teaching business now, right? Y'all can tell, right? No, but that's something we've been know, right? Mm-hmm. Right. That mediocrity and remedial ass shit and all of that, and been saying the same shit for 4, 3. I can't do that. I can't do that. But in 3 or 4 years, I listen here. I done graduated a whole bunch of goddamn students, and they done went on and learned something new. I'm still repeating the same shit. No, I'm not doing that. I'm not doing it. I can't do it. Give you a headache. They have me with the yells and the screams and the cussings and the fussings and whatever, because you don't get it. I ain't doing it. I can't. Uh-uh. I don't even deal with, like, of course, you got a few friends and shit that like neighborhood friends and stuff like that, whatever. That's under the, but maybe a little bit below average when it comes to intelligence or education or whatever. But you already know how to deal with them. They know how to deal with you, and the transference of information and education never results in yelling back and forth, right? Not with this shit. Mm. If I Let me tell you the difference, right? And this is what I tell you: you have to deal with your kind, stick to your people. When I'm speaking with other people in any one of my professions or my personal interests, or you know whatever, if we have a disagreement or a misunderstanding of information or what have you, it results in sometimes an elevated back and forth. Okay. And also this might, it most of the time it doesn't ends in a we gonna agree to disagree. No, because we are two individuals that's interested in the solution. So we're still trying to get to the solution. So we're smart enough to keep work, to continue to work on it to provide some sort of answer, or to see where we are on the same, our what we're thinking align, or where it differs, and if there's an adjustment, there's variables, elements, factors, things of that nature that can change, that may change. Some I might have not considered, some they may have not considered, but that's what it results in. It don't result in no bullshit. No personal stuff. You know what I'm saying? They don't never go there. I'm trying to tell you that ignorance and that being uneducated and unintelligent, that's gonna kill us all, honey. So say the man at the White House. He's living proof. He just got a whole bunch of executive orders, honey. He don't even know what is going to be the potential damage, child. Mm-mm. That's another goddamn topic. But yeah, so that's all I'm saying. Moving on to puppy. We get into the puppy. Oh, I forgot to put topics in here. I be forgetting. Sean P. Diddy. Sean P. Diddy Combs still want to get out, y'all. So apparently Don Wood did an interview. There we go. And I think I should be okay with showing this. I haven't heard the interview. One of the information specialists sent it to me, and when I was looking at the stuff on YouTube, and I went to check, my messages, I saw where she hadn't sent one. I was like, oh, okay. She thinking about what I was already thinking about. Uh-huh. All right. Sorry about that, y'all. But yeah, Karen, them people be studying that shit.
Former Diddy Kane singer Dee Woods is opening up about what it was like working for Sean Diddy Combs. In a new investigation discovery docuseries, Dee Woods claims Combs created an abusive work environment. It comes to the hip-hop mogul is in jail on sex trafficking and racketeering charges. ABC's Eva Pilgrim sat down with Dee Woods for this ABC News exclusive.
With music mogul Sean Diddy Combs' criminal trial just months away.
That's what I'm talking about. Y'all did a great job today, ladies.
Some of those who worked closely with the hitmaker describing for the first time their experiences. Dee Woods shot to fame as 1/5 of the chart-topping girl group Danity Kane after starring on MTV's popular reality show Making the Band 3.
The day we were chosen, I was like, it's bad boy for life, baby.
She says what should have been a dream come true quickly became something else, alleging Diddy created a verbally abusive work environment.
I'm curious why you decided to speak up now.
I would say that this moment now is a time where I feel like my experience, my truth will really be heard and actually considered and believed.
D. Woods sharing her story as part of a new investigation discovery docuseries, The Fall of Diddy.
From the outside, he was this mogul. He was this guy who, you know, could make your dreams come true.
Unsettling scenes like this, a reminder of what it was like on Making the Band.
Juanita, what's your stomach looking like? For real, are you feeling a little thick?
I always feel thick next to these skinny chicks.
You're like a burger away.
He did it in different ways with all of us. You know, picking and prodding and just a way to chip and knock away, but then praise you. I see myself standing in those dark, scary, predatory spaces and hearing somebody say some of the most degrading things to me.
How was it predatory?
Somebody constantly treating you like a piece of meat, only valuing you for your sex appeal. And in some of the environments, you know, it was even scary to be by yourself.
Despite turmoil on and off camera, Danity Kane debuted to massive success. But that momentum came to a screeching halt when Diddy fired Aubrey O'Day and D. Woods.
Based on a lot of things that I've heard, you're not really a happy camper in this situation.
No, I don't think anyone has been happy for a long time in this situation.
Okay, so you could go too.
Are you sure about that?
I'm positive about that.
In the docuseries, D. Woods claims she saw what she says were inappropriate communications from Diddy to Aubrey prior to their firing.
Was there anyone you could have talked to about it?
Absolutely not. Each other.
There was no one to tell.
Because what were they going to do? So it's like, how do we survive this?
Diddy has denied all allegations against him in the documentary. His attorneys telling ABC News the producers failed to provide sufficient time or details for his representatives to address unsubstantiated claims, adding he has full confidence in the facts and the judicial process where the truth will prevail. The accusations against him are pure fiction.
Are you afraid in some ways that he'll get out, that there'll be some sort of retribution?
Oh, yeah. Yeah, even doing this, you know, it's like, maybe I shouldn't say, maybe I should stop talking, shut up, you know, but it's like, you know, well, not talking hasn't changed anything either.
D. Woods has never stopped pursuing her passions, returning to her theater roots and even performing on Broadway.
What would you say to Diddy if you had the chance to talk to him?
I honestly do not know, but I don't think you really have to say anything. As long as I'm holding my head up high and my shoulders back.
D. Woods is still actively performing, actively auditioning. She laughed about how busy it is right now for her because it is pilot season, and she's hopeful about what's to come. The Fall of Diddy premieres tonight on Investigation Discovery and streams on Max. Diane.
All right, Eva Pilgrim, thank you. And ABC's legal contributor Brian Buckmeyer joins me now for more on this. Brian, how big of a deal is it for D. Woods to be breaking her silence in this new docuseries after all this time?
I think it's a big deal for two reasons. One, for the catharsis of a woman who had the ability to speak her story about what happened in that workplace environment. But two, I think a number of people will be watching the documentary coming out today, including people probably from the Southern District of New York, because I think it'd be an investigative tool for people to see, one, whether or not there are allegations that they were not aware of, or two, whether or not there's corroboration through other witnesses who might have seen incidents of sex trafficking or transportation for the purpose of prostitution, those charges that Sean Combs were facing in the current indictment.
Could these allegations end up coming up in the actual trial?
So possibly, the allegations we're hearing from Dee Woods largely surrounds around the workplace environment. It depends on what she saw, what she heard, but also it could come in a sense of MO, in the sense of Sean Combs has a certain MO around individuals or women in the way he interacts with them. And if that MO aligns with the allegations that we have in the current indictment, or even I think we know that there is a grand jury being impaneled now, if future charges align with the allegations we see from Dee Woods, there could be a kind of like a supporting witness type of situation, but I don't think they would go to the heart of the charges that Sean Combs are facing.
How could this special and other coverage of this case impact the case itself, even just jury selection?
Yeah, so it's really going to whittle down who's going to be able to sit down in that jury and hear these cases or these charges, because ultimately one of the first questions will be in jury selection, have you seen reporting on Sean Combs? What is your opinion of that? And it's not necessarily to say if you've seen this, you can't be a juror, but if you have held a strong belief as to the guilt or innocence of Sean Combs prior to the evidence being displayed, and you cannot put that aside and only listen to the testimony or evidence in the trial, you won't be a witness. And so as big as this gets, the number of people who could potentially be jurors become smaller and smaller and become more difficult to find an unbiased jury of Sean Combs' peers when the trial does ultimately start.
All right, ABC News legal contributor Brian Buckmeyer, thank you.
That's an interesting question about, could Don, allegations show up, in the indictment against Diddy? Because remember when I was reading that last, we were doing the Twitter updates. That's why I like that Twitter chat. And Twitter updates, remember, they reference the state now, the state and the defense when they were talking, they referenced the victim 2 and 3. Now wait a minute. They referenced that. Remember, they can read from things that we won't have access to at this moment. They can read from discovery that, or something that the prosecutor has put in or what have you, that would suggest that there's a victim 2 and 3. In the indictment, there's just one victim. So, and again, victim, even although a victim 2 and 3 was mentioned, it doesn't mean that it will ever materialize in that manner, right? We don't know if later on they'll become individuals, or if they'll become, or if they'll indeed become a victim witness. We don't even know if Cassie would be a victim witness, right? We don't, just because she's listed, it doesn't necessarily mean that she will take the stand. However, she probably will, but it doesn't mean that she has to, because as we know, they can put your ass in there, and because they have enough evidence to do so, and not require or ask you testify, right? Oh God, I start eating potato chips with my hand and realize I have no glove, child. Oh Lord. I'm looking for something to wipe my hands off with, but yeah, so that's crazy. So I guess the The documentary may come out tonight or may did it come out tomorrow, whatever, but I will definitely go and see. Let me see the name of that documentary so I can tell you what's the name of the documentary. Okay. Documentary. About Diddy. I don't know, have y'all been keeping up with that? Um, oh, comes on tonight. It's called The Fall of Diddy. It's on ID. It's from ID and it's streaming on Max. And speaking of, you know, making money several different ways, like with one source, and it's pretty much considered cross promotion and all of that. This is an ID, right? This is a investigation discovery production, but it's streaming on Max, right? Think about all the ways that makes money for the different outlets and how it multiplies or whatever. That's how I like to do that. That's one reason why I, learned so many things early on, because I've worked for companies or a company that does a whole bunch of things that deal with a whole bunch of product lines or deal with a whole bunch of service lines or whatever. That way, you end up learning a lot of stuff. You end up doing a lot of stuff. The law is like that, insurance is like that, medicine is like that. Of course, retail is like that, marketing is like that, business can be like that. And that's what happens, right? So you got ID, you got Max, it's streaming on Max. Max is also hooked up with Hulu, and you can get Max on Hulu, you can get Max on Amazon, you can get Max on. You see what I'm saying? That's crazy. This cross platforms, cross promotion, that tree that if you drew that out, you'd be like, oh my gosh. And you put a dollar sign on each at the each end of it, you're talking about maximizing potential. When they taught us maximizing utility in school, honey, of course I made that a meaning that can apply to a bunch of things as well as have different functions. Okay. Like what? I mean, ooh, that's crazy. That is crazy. But that's what it would be premiering on now. What is going? Yeah, there was some movement. There have been some movement in the Diddy case. I've had the paperwork though. So apparently, let me put him back up now. Apparently, Juan Carlos Diddy, of course that's not his name. Check this out. Back on January the 3rd of this year, right? The judge in this case, and you know what I'm noticing about this judge? Either this judge is extremely cautious, or just wants a full picture before he makes decisions, He wants to be well informed about everything, or he confused. Because you notice every time there's a brief that's submitted, which is an argument, he requires them to submit so many, other filings, right, before he makes a decision. If not, an oral argument as well. Now, you do want them to be thorough, right? And I know he be, probably trying to, cover his behind so it wouldn't come back on appeal. But still, my goodness. Let's read what it says. Okay, this is from the judge. It says Combs moved for a hearing and other relief related Combs moved for a hearing and other relief related a search of his possessions during a BOP sweep of the MDC, alleging Fourth and Sixth Amendment violations. Docket 97. The government responded that the search was conducted pursuant to legitimate BOP objectives and that the investigator operated separately from the prosecution team. Docket 117. Let me stop right there, right? Now, remember some time ago, or sometimes with the R. Kelly case, and I know y'all can follow it over here, so sometimes, now I get to tie things together, reference one case to another, right? Something like providing y'all with what? Case law. Okay? Y'all got it. Y'all keep up. Y'all got it. So, in this situation, right, it's kind of similar. The circumstance, the issues are there, right? When you use case law, it doesn't have to be, you can use case law from a drug case for a prostitution case, right? What matters is if the issues are there. What is the problem? What are you trying to solve, right? Okay. So some people think that drug uh, case law from drug cases can only be used in a case about drugs. No, you're looking at the issues and you're trying to do what? Solve them. You're looking for the solution when you're looking for the case law, right? In order to persuade the judge on your behalf, right? But in this case, we see a situation with the BOP. And let me also let you understand this. How can I say this? The answer, okay, let me say this, right? The BOP, right? The search and all of that, that's the issue, right? And apparently but that's not the issue, but that is what happened. That was the results. The problem was with the search. Okay. And I don't know if in some of the filings or what have you, and I think it is, that the defense is trying to say that that the BOP is an extension of the prosecution team. Okay, so we're building a tree, right? If it's an extension of the prosecution's team, then what they did as far as the search and all of that, could give the prosecution an unfair advantage, which is not allowed in law, or a tactical advantage, which is not allowed. And if they are seen as a part of the prosecution's team, then prosecutorial misconduct could be an actual violation if if one did occur, and that would be what unconstitutional, right? Diddy's team, they are like working like, oh my gosh, they exploiting every avenue, right? As they should. That is kind of what Bonjean was getting at when it came to Mr. Kelly, right? Remember that? Remember early on, a couple years ago? She was going the prosecutorial misconduct route, and then she also, saying that the BOP was, I don't know if she actually went all the way there, because I know I went there before she did, but I don't know if she ever went all the way there with that. But I do remember her explicitly saying that it was alluded to. Let me say that because I don't really remember. I know a Brady violation came up, and because I remember the prosecution addressing that it wasn't a Brady violation when it came to those emails and all of that, right? So the issues on both fronts, for is it being prosecutorial misconduct? Would it be a Brady violation? No, that wouldn't be in Puff case. It would be Brady, I don't think. But definitely, if they can make the BOP part of the prosecution's team, then it could be a prosecutorial misconduct. Although the BOP is not a part of the prosecution's team, if the actions they deployed and the work they've done with regards to that raid could be seen as them working for the prosecution, and it gave them an unfair advantage, yeah. So, and I don't think it's a reach for the defense, because obviously those arguments have been made on the floor before, right? I just think that the steps from before the raid and after the raid is going to be carefully examined, right? And if this outcome goes against the defense with regards to their argument, them being, the BOP being an extension of the prosecution or whatever, it probably is going to come back on appeal if he is found guilty. That's just my opinion. We can watch for it. Okay. It says, in evaluating Combs' motion, the court would find the following additional materials helpful. One, an affidavit from the prosecution team stating its understanding of the chain of events leading up to, during, and following the MDC sweep. Just said, including investigators one's role, and two, an affidavit from investigator one describing his role, the circumstances under which he participated in the MDC suite, and the extent of his communications with the prosecution's team, including any communications in advance of the MDC suite or about the MDC suite. These affidavits should be furnished to the court by January 17, 2025. By the same deadline, the prosecution team should produce its written communication with investigator one, if any, for the court's in-camera review, meaning behind the scenes, right? That's crazy. Why would they use in-camera to mean behind the scenes? Baby, I don't know. I ain't write this, but that's what it means. So, again, I think that the judge is asking for all those steps so he can evaluate if the BOP in this instance should be considered a part of the prosecution's team. Now, if that step, if that argument would have been made during, when did that raid come out? Did it come? I mean, not raid, Lord. The email theft come out? Did it come out during the? Did it come out? I think it came out during the It did come out during. Hold on. I'm trying to see when it came out with regards to Mr. Kelly. Stolen BOP email. So it says September 8th. When did that come out? What's the date? See, I mean, did they do it? Well, okay. So if Tasha K put that out, Tasha K put that out somewhere in 2020 or something like that, at least 2021. I know by that time. His defense team, if my dates are right, now if this was beyond the trial, then don't worry about what I'm saying. But if it was during the trial, his defense team could have, made an argument, with regards to this, the same argument that as Diddy's team is saying, hey, y'all extension of the BOP, gave y'all an unfair advantage, blah, 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 so on and so forth, right? Made an argument that was prosecutorial misconduct. Try something, right? That's pretty much what I'm saying. Try anything. Try something if you are defense. I ain't bashing them. I don't know. And here's the thing, right? You can't call it a Brady violation because if the defense knows about potential evidence as well as the prosecution, then it's not a Brady violation if they could have discovered the the evidence themselves. Okay. Just because the prosecution didn't include if people think sometimes that just because the prosecution didn't include it, it's automatically a Brady violation. No. If they didn't include it, but you knew about it, it was discoverable by you. That's what discovery means. It's discoverable. Okay. So that's the out they give the prosecution when it comes to Brady. One of the outs, anyway. So that request by the judge brings us to I got an order and everything, David. Okay. So this is what the government says. Responding to the judge. All right, it says the government respectfully submits the attached declarations in response to the court's January 3rd, 2025 order, which I just read, and in further support of its opposition to the defendant's motion for a hearing and other relief, docket number 117. At the request of the Bureau of Prisons, BOP, the government respectfully seeks to file the declaration attached as Exhibit B under seal. Based on communications with counsel from BOP, the government understands that the information contained therein reveals sensitive law enforcement techniques and reveals the identity of an employee involved in the ongoing BOP-led investigation. And notice how they put in there BOP-led, because we know what you're trying to say. You're trying to, again, lawyers know what each other is trying to do, right? They, that's why with some of the stuff I can tell you exactly what they're trying to say and doing where they're trying to go with it without them actually stating or whatever. Because I tell you, like, they're talking to each other. They really are, talking to, y'all, and then we all have the, some of the understanding. Of course, they are trained trial attorneys and stuff. That ain't got nothing to do with me. I'm just going from general knowledge from back in the day. Anyway, so, and there's some case law, and it was the Second Circuit back in 2010. It says, among other interests, law enforcement privilege prevents disclosure of law enforcement techniques and procedures and protects law enforcement personnel and safeguards the privacy of individuals involved in an investigation. Child, you can tell when a teacher or instructor wrote something because it was authored by somebody using a whole bunch of it's not a whole bunch, but using alliteration. You see all them P's and shit. Procedures, protects, personnel. All right, it says, finally, with respect to Exhibit A, the prosecution team declaration, the government provides information required by the court, but in doing so does not waive any applicable privilege, including law enforcement privilege and deliberative process privilege. There's more case law. And this is the Second Circuit, 1991. Deliberative process or executive privilege protects the decision-making process of the executive branch in order to safeguard the quality and integrity of government decisions. So that's just telling the judge that the process that happened here, it favors the government. The government should be given more consideration, right? Because it did what it did and the reasons why they did it. If you're going to say that the BOP is a part of the prosecution team. And if you're going to examine the evidence that they apparently are trying to use, then deference or consideration should be given to their actions. And when you're making this decision, and they apparently have some sort of case law to state that. And there is Christy Slavink listing out her credentials. And this says the BOP's monitoring of the defendant's communication and custodies is based on my decisions with a USAO Southern District New York unit chief who directly supervises the prosecution team and the prosecution of the defendant. Supervisor 1, I have learned that on about October 10th, 2024, BOP personnel contacted Supervisor 1 and informed her that a BOP intelligence analyst, Investigator 1, had been monitoring the defendant's communications from the MDC and had found apparent attempts to circumvent monitoring, as well as the use of coded language and possible attempts to engage in witness intimidation. That same day, Supervisor 1 requested transactional data, the defendant's email and phone contact list, and the defendant's email from the BOP, and I served the BOP with a grand jury subpoena for non-attorney phone calls placed to or from the defendant. Since that time, I have been the member of the prosecution team primarily responsible for liaising with the BOP, including Investigator 1. On or about October 13, 2024, I spoke with Investigator 1, who provided an overview of some of the defendant's calls that he had monitored. Investigator 1 also detailed the unauthorized methods of communications the defendant was using, including using other inmates' PAC numbers, using three-way calling, and using a third-party messenger service. I spoke with Investigator 1 on several other occasions in October and November of 2024. And they get into the planning of the MDC suite. And there's the other suite that we heard about. And it says the prosecution's team in communications with Investigator 1 following the MDC suite. On or about November 3rd, 2024, following the completion of the MDC suite, the prosecution team first became aware of Investigator's 1 involvement in the MDC suite through a phone call between myself and Investigator 1. Investigator 1 informed me that he had spent time in the defendant's unit, i.e. Unit 1, and checked the defendant's bunk area for contraband, including cell phones. Investigator 1 had informed me that he took photographs of certain of the defendant's papers and an address book, the BOP notes. Investigator 1 provided a high-level overview of the contents of the BOP notes, including the defendant's plans to discredit possible witnesses and find dirt on people. Ooh. At the conclusion of the November 3rd, 2023 call, I requested that Investigator 1 send the BOP notes directly to the AUSAs leading the filter team, i.e. the team charged with reviewing material that may contain attorney communications or work product, by email and attorney communications portion of that means attorney-client, and work product means that um, evidence or not evidence, but information, like notes or preparation of things of that nature that's used for trial, right? All of those things, if in the hands of the opponent, would give a what unfair advantage. Okay, and again, that's not allowed. And it says by email later that day, the investigator one confirmed that he had sent the BOP notes directly to the political team, AUSA. And it says Exhibit B is under seal. Okay, you know, these people are these people talk a lot. The defense team, they talk a lot. Hold on for a minute. Let me use the restroom. 1 minute. Okay, folks. Sorry about that. Old lady, old bladder. Okay. Now let me see what's all up in here that I need to read. Oh, I'm glad they got the big monitor up there. I can read it from the big monitor. Okay. It says, let me see if I can get practice there. I got to look straight ahead. All right. It says, we write on behalf of Sean Combs to respond to the declaration submitted by the government on January 17, 2025, and in further support of Mr. Combs' motion for a hearing, suppression, and other relief. The declaration shows that ever since the government first tried to use Mr. Combs' privilege notes to continue his detention, it has presented a materially false narrative about how it got access to the sensitive, privileged materials contained in his defense strategy and communications with his attorneys. Most significantly, the declaration revealed SDNY supervisors directed the BOP to search Mr. Combs' unit because of its investigation and prosecution of Mr. Combs. And they demonstrate the government has consistently monitored Mr. Combs' legal calls. In other words, they confirm what Mr. Combs has been arguing all along, that the search was conducted based upon a pretext, not for any legitimate pre penological reasons, and that investigator one's surveillance before and during the search violated Mr. Combs' constitutional rights and invaded the attorney-client privilege. So penological reasons, meaning that the prisons would be like, it's for study or it's for some kind of reason or some kind of behavior or something like that. The reason why we are searching and things of that nature. Again, the government, the law, or what have you is always going to provide itself an out. I told you that a long time ago. Even though it's going to establish a law, a rule, a regulation, it's going to provide itself with a out, to circumvent those things, right? I mean, because, and this is the reason why, because everything isn't, you can't make a law for everything and apply, you can't make a law for anything and apply for everything, okay, for all circles, because it's going to be something out of the norm that comes up. It's going to be a good reason for something to happen, just like, with attorney client, right? You can protect your client if he gives you information about old crimes, but if they are trying to, if they're, if they are I lost my train of thought. If they are, if they are, if they are planning on, if they're in a commission of a plan or planning on trying to kill somebody and shit, yeah, you get to tell that, right? That's not protected under attorney client, right? Again, so that is what they are. That's why they, do all give, they provide a little out, a little window. Sometimes it's a small window, but you can still get through it. Right? It says first, the declarations refute the government's repeated claims that the VLP sweep was carried out solely to further legitimate penological interests and did not target Mr. Combs. The declarations exposed that after the sweep began, it was unclear whether Mr. Combs' unit would be searched at all. Moreover, the search of that unit was carried out specifically at the direction of SDNY supervisors, including the supervisor for this case, because of their interest in obtaining evidence against Mr. Combs. Oh, they saying that the super, that the prosecution's office child carried out the case and not The BOP? Is that the truth? Maybe that's why Mr. Judge Samaranian, whatever I pronounce that man's name, wants more information. Oh. Second, the declaration showed that Investigator 1 became an agent of the prosecution team and worked to advance its case. Okay, bam, 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 bam. I knew I was right. So the defense is trying to say that in this situation, the BOP is an extension of the prosecution's team, right? Again, if that would be the case, then that can be considered prosecutorial misconduct. Although within the federal government, everybody works for an agency. Well, just about everybody works for an agency. Does everybody work for an agency? I'm not sure, but in the Department of Justice part of it, everybody works for an agency. So, although if you look at your tree, it is connected to one tree, right? The government, right? However, you do different jobs. Some people can do the same job. Some people can, from different agencies can work on the same case. You know, it's at the government's discretion, and you can pull from different resources, right? Okay. You can get another resource from another agency and so on and so forth. In this particular case, right, when you are trying to make an argument that in civil cases, and this you'll see this a lot in civil cases, as I explained before, when you're suing a company and there is an independent person that doesn't work directly for that company, but whatever duties they performed or whatever actions they may have performed or what have you, and a lawyer can make an argument that whatever duties or actions that independent person performed was at the benefit of behest of the three B's: the benefit, behest. I forgot my own shit. Benefits, behest, benefit, behest. What's the three B's, y'all? Benefits, behest, on behalf of, right? That particular company. And if the judge views that person as an employee based on that person's actions, behaviors, job descriptions, tests, all of that, then that company can be held liable, right? Meaning, and you do that, why? Because most likely the broke ass independent person ain't got it. That company do, right? Okay. You're gonna attach a garnishment to the company's profits and what have you. You probably can get it from there. So let's see. So the declarations exposed that after the sweep began, it was unclear whether Mr. Combs' unit would be searched at all. Moreover, the search of that unit was carried out specifically at the direction of SDNY supervisors, including the supervisor for this case, because of their interest in obtaining evidence against Mr. Combs. Okay, so they're trying to make a direct connection. Okay. Second, the declaration showed that Investigator 1 became an agent of the prosecution team and worked to advance its case. Remember the unfair advantage or tactical advantage, right? He searched Mr. Combs' bunk for evidence, not contraband, and it is clear his purpose was to gather evidence for the prosecution, not police any potential threats to the MDC security. Indeed, it is possible. Is it possible? No, I'm sorry. Thing was in the way. It is notable that even though he has been surveilling Mr. Combs' communication for months, to this day, the BOP has not taken any actions to discipline Mr. Combs for any purported violations of MDC policies. Mr. Combs has never received so much as a write-up in his 4 months in BOP custody, despite the government's repeated complaints about his alleged obstruction from MDC and supposed violation of policy. Third, the declarations confirmed that the government was complicit in Investigators 1's continuous monitoring of Mr. Combs' privileged communications. Investigator 1 admits he listened to Mr. Combs' calls, including with his counsel, and that all those recordings, including the ones with attorneys, are being furnished to the U.S. Attorney's Office. So they get them on Sixth Amendment, Fourth and Sixth, right? Also, they're coming at them with prosecutorial misconduct. So you got privacy, you got privacy, you got prosecutorial misconduct. So I put them P's together real quick. And so privacy, privilege, and prosecutorial misconduct. Wow. I don't know. When I tell you that money in cases make a difference, and it doesn't mean that, um, that it should make a difference. What I'm saying is they have more resources, more active bodies. They're able to go out and get, what they need to do the job a lot faster and probably, more efficient or whatever, rather than just one or two people working on a case of this magnitude. And think about it. He only got like what, um three counts? And I think they all pretty much related to the same person, pretty much the same thing, kind of sort of, right? It's not different people. Like in Mr. Keller's case, it were different women, different circumstances, a lot of shit going on. He had a team, at different at all times he had a team of attorneys, that brought their own resources to the table. But it just makes a lot difference when you got an unlimited, you know, money supply for something like this, and you could just do a whole lot. It doesn't mean that the job would be done any better, but I'm just saying it's just the possibilities are endless with sometimes when you're working with a smaller group and a limited, bank, you know, bank supply, you know what I'm saying? And then sometimes the efforts may be limited as to what you can do. Okay, because all the time when you reach out to an investigator to do something or an analyst to do something or something like that or whatever, they all the time they're not gonna do it just because you're their buddy or they're gonna do you a favor. Sometimes they're gonna know I need money because what you're asking me to do, I got to pay for. They'll give you that quick. Y'all know how that works. And I won't charge you for my time, but these utensils I need, and I got to pay somebody else to pull the stuff and all this, that's gonna cost me. I just like, you don't have to pay for that. You know how that works, child. And it says, finally, the declarations raise additional questions that cannot fully and accurately be answered except through discovery and I can't see, evidentiary hearing, my bad, as just one example, despite reporting to prosecutors that he personally took the photographs of Mr. Combs' notes. I'm trying to look back where I was looking so I can see. I'm trying to be fancy, child. Let me make it bigger. The declarations are inconsistent with each other, omit key details, rely extensively on hearsay, and are remarkably vague as to key points. The truth will only be fully revealed if the government's claims can be tested through cross-examination of witnesses who have actual knowledge of the material facts. Likewise, the court cannot fashion appropriate remedies without the complete information that can only be discovered through such a hearing. So they're trying to get a hearing. Okay, let me read this paragraph. It says the government represented the facts and tried to conceal the constitutional violations. SDNY prosecutors, not the BOP, directed the search. See, they got some good points here. The declarations contradict the government's prior representations concerning the reasons for the search and who directed it. The government previously claimed that the MDC sweep was planned by prison officials well in advance of Mr. Combs' arrest, was motivated solely by legitimate penological interests, and did not target Mr. Combs. It further claims no one on the case team supervised, conducted, or participated in the search, and that the search was organized and executed primarily by BOP staff. These claims were essential to the government's opposition, which rested on the notion that the prison officials are presumed to do their best to evaluate and monitor objectively the security needs of the institution, including in deciding whether a search is necessary. But these claims were false. The truth is that the search of Mr. Combs' unit apparently was not even part of the BOP's original plan for the sweep, but it was SDNY supervisors, including the trial team's own unit chief, Supervisor 1, who ultimately directed the search. And the search was conducted not for legitimate institutional security reasons, but because Supervisor 1 was interested in searching Mr. Combs' child. Now, if that's true, child, specifically on the morning of the second day of the sweep, representatives from the BOP and other federal agencies met to discuss a potential search of Mr. Combs' unit. The agencies had not previously decided whether such a search was necessary and inquired into the positions of the USAO SDNY regarding the potential search. Supervisors 2 and SDNY unit chief, who helped plan the MDC sweep and was present during the sweep, then discussed with Supervisor 1 whether Mr. Combs' unit should be searched. Supervisor 1 stated that it should be searched, in part because of what the prosecution team had learned regarding Mr. Combs' conduct at the MDC. Supervisor 1 conferred with SDNY senior leadership and relayed to Supervisor 2 that Mr. Combs' unit should indeed be searched with Supervisor 2, further relayed to the BOP leading to the search. Thus, while AUSA Slavic claims that no SDNY personnel directed how the search of Mr. Combs' unit would be conducted, she can't deny that SDNY supervisors directed the search itself. Ooh, that flatly contradicts the government prior representations. The investigator one was searching for evidence, not contraband. I think they already went over that ad nauseum, so we don't really go to that. The government did not proceed in good faith and took steps to avoid. The government did not proceed in good faith and took no steps to avoid violating Mr. Combs' rights. The declaration showed that further discovery and a hearing are required. But investigators one declaration lacks important details. Says the prosecution team also includes Supervisor 1, Supervisor 2, and SDNY senior leadership. Child, you can see it. Now I can read it to yourself. Read it to yourself, child. That the government should produce the emails and other evidence. Says the government mentions email communication Slavic, and the MDC is wired with surveillance cameras that recorded the relevant search. The court should order the production of this evidence and any other evidence in the government's possession relevant to the motion. It is the most reliable means of testing the government's dubious claims. Instead of sharing the full story, the government has cherry-picked a few facts and submitted declarations that undermines the credibility of its previous submissions, omit key facts, and raise numerous important questions about what really happened. A full hearing in which Mr. Combs' counsel are afforded the opportunity to cross-examine the government actors with knowledge of the facts relevant to the search is the only way to find the true facts and understand the full picture so the court can assess how best to remedy this grave violation of Mr. Combs' constitutional rights. Mr. Combs therefore respectfully requests that the court order the government to produce the additional discovery described in this letter, as well as whether communications it has already shared with the court in camera, and hold a hearing. Mm. Child, I done hit y'all with one of them teacher student move. Read to yourself. Hey, I had just thought about it. I said, you know what? How long I've been asking students to read it to themselves? Stop it right there and read to themselves. For almost 11 years. Almost 3 on a part-time basis, and um shit, 8 on a adjunct full-time basis. Are you crazy? Yeah, read to yourself, honey. Yes. What up, Red? Read it to yourself, honey. Yeah, I want me more a sandwich or something. I want me something with a hard um hard shell to it. Taco. Yeah. So, so that's where they are with it in Puppyville. Let me check them traps real quick to see if there is anything else that have come out since I pulled that. That was the latest for today. Oh, Lori Lightfoot came to give her final findings on Miss HENYARD. Let me clear out Puffy before I move on. Well, we're moving on now to the sky. I don't care what you say. It's certain things that you can duplicate from a restaurant you like or whatever. It'd be, pretty close. It'll be real. Uh-oh. Hold on. Glad I checked, child. Glad I checked. Glad I dared check. Give me a second. Let me see if I can find a sample. I seen an anonymous interview with one of the CEOs with Diddy, and he says that the notebook they took pics of has all the information on his witness intimidation plan, like who needs to contact, who to keep them quiet. What? Now I don't care what nobody say. I'm still fat. I don't care what nobody say. And baby, my belly be sometime. And it's not that I don't eat no 3 meals a day, and sometimes I don't even eat, right? I be having a lot to do. I ain't got time to be eating and shit. But baby, I want me a whole sandwich. Like a BLT child. Oh, I want a BLT. But I don't. And see, sometimes I go on in and out with a tomato. I really don't like tomatoes like that. Child, they got something. They got a BLT for $17. By the way, when I call out the prices like that, you know which location I'm in. Pay attention to your ordering services. And depending on where you are, them prices be different. The price be different for food. The price be different for that goddamn, like grocery. And the price be different from the damn restaurants. Tell me I'm lying. Same goddamn food chain. A BLT was $17. Well, I take it back. It ain't the same food chain, not a national food chain, anything like that. But this, one of them little niche little place. You know what I'm talking about? One of them little bullshit like that. $17 for goddamn BLT. What the fuck comes on it? Can you tell me that? What comes on it, honey? Applewood cured bacon, powdered high with lettuce, tomato, garlic, peppercorn mayonnaise. Huh? And they serve beer. A YUENGLING lager. I don't know what that is. Should I get it? Should I get it and come on here and trip y'all? Should I do that? Like, huh? So, let me tell you something. This is how you run out of money. I learned that quick. Now here go a BLT for $13.20. I, listen. This crazy. Let me erase this address out here. You think I'm playing? Can I erase the address? I'll tell you what, I'll take the pickup. Would y'all pay $17 for a goddamn BLT? The fuck? I mean, what come on it? Gold or what? Like what? BLT chair. That's crazy. Uh-uh. 17 damn dollars. Has gas gone down? They got a burger with 4 patties. Huh? I should say they got a heart attack for 4 patties. I'm coming, y'all. That's them little places. You know what I'm talking about? Like, uh, uh, and I already feel my stomach trying to not cooperate. Yeah, I don't know about that. I really want a BLT. And I really just want the bacon and the lettuce. I just really don't want to make it. Sometimes when somebody else fixes the shit, it is better. You love BLTs? Like a BLT for 17. Have you ever bought one for $17? I'm just trying to figure that out. What the fuck is on that? Is it, huh? It looks real good. Oh, can't you do that thing where you can take a picture of the screen? I think I can do that. I can do it like the old fashioned way. This crazy. This is crazy. Apple occurred bacon, pie, hot, lettuce, tomato. Damn, that sounds good though. $17. I don't even know the why you eating lager is. I don't know what that is. So I don't want none of that. Pepper shooters. Nope. So it's gonna burn my belly. Ooh, y'all, it's one of them little shops they got. Y'all ever ate some like them places that had that ham on that sandwich where the ham be kind of sweet? Y'all know what I'm talking about. This is big girl shit. If you ain't no big girl, get out, cause y'all ain't gonna understand what I'm talking about. Ooh, why all the sandwiches like almost $20? They got a provolone cheese, Genoa salami, spicy capicola. Ain't somebody in Italian? Baked ham, prosciutto ham. I don't like prosciutto. For 18.25, I'm trying to figure out why is all the sandwiches um why all the sandwiches that high? I almost $20. What? Huh? Me and my friends been doing that. What? Huh? When you hear something you just don't understand. Ooh, I'll be frank on it. Okay, let me move on to I think I'm gonna cue this problem by cooking. So hold on and put that on the screen. Mm, 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 mm. I'm gonna put a document up. Silicone. Silicone 127. Oh, Keefie D, child. Oh, that's sad. Keefie D done got his all that talking, trying to make a couple dollars. Baby. Keep it punkin'. Um, mm, that, that one off. Okay. Get that off. Here we go. So, in response to all of that we just went through, the government is saying the government respectfully submits this brief response to the defendant's letter dated January 24th, 2025, one I just read. In the January 24th letter, the defendant makes a number of new and unsupported allegations of misconduct against the government based on the declarations filed by the government and the Bureau of Prisons in response to the court's January 3rd, 2025 order. They're going to get into it, child. Let me look this way. What was that? These allegations contort and misrepresent the contents of the declarations and do not merit consideration by the court. Most significantly, the facts laid out in the declarations clearly refute the defendant's spurious allegations that Investigators One conduct during the sweep was directed by the prosecution team or done to obtain evidence against the defendant for this criminal case. Oh Lord, was they lying to the judge? Let's see. Oh Lord, the defendant's other allegations similarly ignore or misconstrue the facts. For instance, the defendant argues that the government was complicit in Investigators One monitoring of Combs' phone calls for the BOP. But Investigators One statements make plain that his monitoring was properly and independently done as part of his BOP duties. Moreover, any attorney communications obtained by the government were provided directly to a filter team for the express purpose of presenting the defendant's privilege. I'm sorry, protecting the. Let me blow it up. Hold on, I can't see. Protecting the defendant's privilege. In sum, these new allegations do not support the relief the defendant seeks, including additional fact finding. Nonetheless, should the court be inclined to consider these new claims in deciding the defendant's pending motion or request for a hearing, the government first requests the opportunity to respond in full to the January 24th letter. To be clear, however, the court need not consider these new allegations because even if taken as true, which they cannot be, the allegations cannot cure the fatal flaws in the defendant's motion for discovery and a hearing, as set forth in the government's opposition brief, and as underscored by the facts set forth in the declarations. The defendant's Fourth and Sixth Amendment claims are mute and meritless. First, the defendant's Fourth Amendment claim regarding the MDC suite is mute because the government will not seek to offer the defendant's notes photographed by investigator one, or any fruits of those notes in prosecution of the defendant. Meaning, they're not seeking to use it or any additional evidence that was produced as a result of those photographed by the investigator one. So they're saying it's null and void. They're saying they're not going to use it or anything that came from those particular notes, right? Or any, because sometimes you may come across something that leads you to investigate something else. So anything that bear fruit with regards to from that particular piece of evidence. They said they're not going to use it. Second, with respect to the defendant's Sixth Amendment claim, despite his latest efforts to twist the facts in the January 24th letter, the defendant cannot show that the prosecution team, which does not include investigator one, intentionally interfered with the defendant's attorney-client relationship. No, they didn't say the man is on the prosecution's team. Lord, and the government said that people don't work for them. Like, damn, come on now. Just all in all outline. If what the government is saying is true. So it says, even if the defendant's misleading assertion that the government directed the search of his housing unit were credited, it is not disputed that the government had no knowledge whatsoever that investigator one would take part in the search or that the defendant's papers would be photographed. Ooh, okay. They're saying that they didn't have no clue who we were on the team, if that was the case, or that the actions of them being on the team, that they had any knowledge of, prior knowledge of. That's just normal, search and procedure. Okay. However, the defense can't come back and say that I don't care if you had any knowledge of it or not, what would happen, what didn't happen, or anything like that, because that was your person as a part of that search and seizure team, that their actions is squarely your responsibility. They can come back and say that, right? I mean, now this is just, this is an Angie thing, but let's see. And moreover, all photographs taken during the MDC sweep of the defendant's papers were provided to the filter team in the first instance, consistent with the government's practice of providing all other potentially privileged materials obtained from BOP to the filter team for review. Accordingly, the defendant's Sixth Amendment claim must fail, and there is no need for discovery, a hearing, or any other relief requested by the defendant. Daniel Sassoon. Ooh, I know them people ain't just flat out lie to us and the judge. Come on, now, what I told you. You got to swing, baby. You got to swing, honey. You got to do what you got to do. Shit. The fuck? Mm-hmm. Yep. That was funny. I'm glad I did check the traps before I got up out of there. Off of Diddy. All right, moving right along. All right, let's do a ASAP Rocky catch up real quick, right? You got your girl in here. You got your cigarette smoking girl. Woo. Okay, it says lawyers in ASAP Rocky trial ask prospective jurors about Rihanna's influence over their verdict. Well, I am doing that. Hold on for a minute. I know what I can be doing. We need to hear this. Okay. We need to hear this. Y'all, let me pivot real quick. Let me pivot real quick. Let me put this on the schedule real quick. Because we cover Dalton too, honey. We need to know what's going on. Lord have mercy. I appreciate y'all bearing with me and sticking on the note with me. Well, I'm going to get through all of the topics. Yes, I am. Yes, I am. And all through, when something reference one case to the other, whatever, whether it be R. Kelly, whether it be Diddy, whether it be whoever, if something in there bears some similarities, whatever, I will point them out. Um, because some of the charges are similar, right? So certain arguments, so certain factors, it's gonna be the same. But honey, baby, we need to know about this now too. Hold on, real quick. I mean, Tiffany, the only way Tiffany name now would be on that ballot as I think supervisor is if she's a write-in. Because the government, the judge, and again, when I say government, I mean, I don't care if it's state or feds, it's still the government, right? Okay. Let me put this up on here, Hunty. And we got a lot of Chicagoans. Y'all need to know about this now, because this now is crazy. Now this is her final, Lori Lightfoot's final report. Remember, she did the report about 5 months ago, right? That gave the real true numbers based on her preliminary investigation that the Dalton was, in the negative, right? At a deficit. Tiffany numbers show something different. CPA, and I think the same one that usually certifies for that township, could not confirm her numbers. I think they have been able to confirm the latest reports that Tiffany have submitted. So, hey, but it's very interesting because now the FBI is involved, and she has some other investigations. Plus, she is being sued from everybody and their mama. I don't know what's going on. I don't know why her eyes be. I don't know what the fuck is going on. If she not, again, when they be on that praying thing, that I don't know. And you hate to, because it's almost like you sound like you doubting God. You ain't doubting God when you telling somebody, listen here, I understand that you are praying, but you got to be praying that nothing comes from this, or maybe that you get what you want in the end, right? But you can't be praying that none of this ain't happening when it is. That don't make no sense. So at that point, I'm not challenging God, I'm challenging you. Like, what are we doing? I'm challenging you, honey, at that point. That's what all I'm saying. And that's what I be trying, because you're not loving, so I know it might not seem like it sometimes. But baby, I love the Lord. Now I don't like nobody using them, abuse them. I don't like them hypocrites. I don't like none of them type people, right? I don't like none of that. And I ain't got to know every word, every little Bible to know what's right and what's wrong. I got to know none of that. It's almost common sense. And more than if you was taught what's right and what's wrong, it is a feeling within yourself. If you a person that means any good, that you're right. So whether whatever you was told, taught, whatever, that's neither here nor there. With your heart and what you feel. Now, if you are evil motherfucker, then none of this pertains to you. You don't get it anyway, and don't even worry about it. A lot of people, and again, a lot of people like to use the Bible. A lot of people like to use the word to trick you, to produce their narrative, to push their narrative forward, to protect their narrative. How about that? And it's in the end, it's bullshit, because it's just like, if I hit myself in the goddamn head, hard enough, is it gonna hurt? It's just that plain and simple. It's just not enough. But so I don't like all of that. I don't like people that play all the words and draw them games and all this bullshit, whatever. If I walk through some motherfucking fire, is it gonna burn me? Yes. It ain't whether nobody told me it's gonna burn me. It's not whether it's going to burn. I don't even have to walk through the fire. I know that. It's common sense. It's an element of the earth. Yes, it's going to burn. Like, what are we doing? I don't like all that. So Tiffany be on that. I don't know. When people be praying and stuff, I don't know what the fuck is going on with all of that. But you hate to say something to them, super say people and praying people and all that, whatever, because it sometimes it can seem like, well, you challenging the Lord. You know how they play them games with you. And so that's why I don't like playing all of that. I don't like doing all that. So that's why I like dealing with type of people. I stay way One of the type of people. That's why a lot of times I be saying my type. I don't be necessarily meaning educational wise and this, that, and third. I'm talking my type. Okay, I don't like people that play all them kind of games with the words and the this and that and the whatever. It's bullshit. And when you do that, you sketchy and you're full of shit. I don't do that. I don't deal with you. I don't deal like that. And I will cuss you out. And just because I cuss you out don't mean I'm mad, angry, or angry black woman. No. I'm okay, whatever. I will cuss you out and I'm happily cussing your ass out. I'm happy to cuss your ass out. How about that? And to be honest, a lot of bullshits, whatever, they always get away from me. They always, have their guards up with me because they know I can see right through them. Even though I might not say nothing, but when I go to tell you about your ass, they be like, "You kept that from 10 years ago." Yes, bitch. I'm just waiting the time to tell you about your motherfucking ass. Tell you how fucked up individual you are. They be like, she'll hold on to shit forever and she won't say nothing. You'll be thinking, da, 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 da. Yeah. I mean, I'm watching your ass. That don't mean, huh? Shit. Sometimes I got to watch it. You got to keep them close to watch. Shit. God damn, I take my training everywhere, and then my common sense, and then what your parents tell you, I take a lot of wealth of information with me from various sources. I wrap it all together, and I've been doing this for a long time, been here for a minute, but yeah, I don't like all that. Tiffany sit up there and tell you that it ain't so when she tell you got all this money and this people, this, and the people shit ain't being paid. People ain't getting this, getting that, whatever, and she'll tell you that like it ain't happening. I don't like shit like that. I don't fuck with people like that. Bitches, you crazy? I don't deal with people that play them type. I can't stand that. Stop that. That's ridiculous. And I never support no motherfucking shit like that. And I'm always gonna be on. I don't listen. Or I just won't say that. I never support no shit like that. I don't support people like that. Or I just shut the fuck up. Because sometimes, okay, if you're in a party of people that you didn't put together, it's gonna might be some fucked up people in that party, but you got the same goal and objective. A lot of times you can't say this motherfucker in this party, whatever. We're on the same team, but they full of shit. A lot of times you can't say that. Okay, so I just hush. I don't support no. I just be quiet. And when it comes down to my part, I just make sure that I try to, no. I don't play them kind of games. But yeah, she's sitting up there. Then she wants to blame. She wants to say that the other people stealing the shit when they the ones doing all the stealing, and it ain't her. And then she played the game, but these things needed approval. I couldn't do it. It's the trustees that had to approve the stuff. Sweetie, it's your credit card. It's you the one it's your credit card, boo boo. You the one is in possession of the credit card. The trustees can't shut your credit card down if you got possession of it. They have to go to court and do and then an investigation have to ensue to prove. It's a lot of stuff. They can't just shut your credit card down immediately. I wouldn't presume that that's how it works because they got a lot of rules and regulations of how they do things in that level of government. They are assembled for checks and balances reason. But you got the credit card, and if it's your credit card that's making the charges, how you gonna blame it on somebody else? This is them games, child. And I don't even know if you know what I'm saying, but I got common sense and I know how basic things work when it comes to boards and things of that nature. I never been on trustee board like that for no government and stuff like that. But I'm on enough of them. I've been on enough of them, and work with people that's been on enough of them. That, and they give you your own independent corporate. Come on now, like the bullshit.
Good evening, everyone. Good evening, everyone. Thank you all for coming out on a cold night, and hello to those folks who are watching on the live stream. My name is Lori Lightfoot, and with my colleague Amanda Kite, we're from the Charles River Associates, and we are here to provide to the members of the Board of Trustees and the public our final report regarding our investigation of the allegations of financial mismanagement and other matters concerning the Village of Dalton. A couple of quick housekeeping matters. You should and should be circulating index cards if you want to ask us questions. We're going to go through the entire presentations first. I'm not promising you that we're going to be able to answer everyone's question, but we'll try to get you as many as possible. We will set up, for those that we aren't able to answer, we will set up a microsite and have answers to the different questions there. Also, that's circulating is a document that if you want a hard copy or electronic copy of this PowerPoint presentation, give us your name and your email address, and we'll make sure that you get it within the next 24 hours. All right. Well, make sure you fill out the paperwork. There's signing the sheets going around, and you should be able to put your name and your email address, and we'll be able to provide you with a copy of the deck. The deck is long, and given the number of people that were here, we felt like it made more sense to provide electronic copies and try to anticipate how many people would want a copy. So let me start by saying that, as you know, we began this investigation in earnest back in the spring of 2024 after the trustees overrode a veto of the resolution of hiring us through the Legislative Council. We were tasked with looking into irregularities, allegations of irregularities regarding financial mismanagement by Mayor Tiffany HENYARD and others in her administration. And I want everyone to be clear, we are not conducting a criminal investigation. This is an investigation that depended upon witness testimony that depended upon getting access to certain documents. And to be clear, we did not receive total cooperation in this investigation. In fact, we encountered many challenges getting access to relevant documents and information from the very beginning of the engagement. We do not have subpoena power as an independent investigative team, which would have allowed us to obtain materials and cooperation from individuals. The village's personnel policies do not require cooperation with internal investigation. That could prove to be a challenge in this circumstance. And a lack of cooperation by some individuals led to delays, limited our abilities and scope of work, and ultimately limited the information that we were able to address in the course of this investigation. Despite these obstacles, we made progress in providing information to the trustees and to the public on the true financial condition of the village of Dalton, along with some other issues. And as a result of that, we're able to make some concrete recommendations, many of which the trustees have already adopted, on how to right the ship, to make sure that there are financial guardrails in the operation of city government, and to provide some other supports that would all be in favor of transparency and good governance. For those of you who don't know, we thought it would be important to give just a little bit of background about the village of Dalton. The village was incorporated in 1892, and according to the most recent census data, the population is approximately 21,426. The median household income is 58,706, and the village is approximately 91% African American. The village has a trustee form of government, which matters under the organization of the Illinois Municipal Code, and we'll talk about that briefly in a moment. The keys to the employees for the village, aside from the trustees, are the mayor, the village administrator, the director of administration, director of finance, and the staff accountant. Now, I'm not going to read everything on this slide. This is excerpts from the Illinois Municipal Code, but suffice it to say that the code really is a set of specific mandates on how a trustee form of government and other forms of government are supposed to conduct themselves. It provides things like there should be an annual appropriation, and ideally that is done in the first quarter of the village's fiscal year. No official can incur debt over and above what the budget is unless there is a 2/3 majority vote by the board trustees. There can't be entering into contracts without a corresponding appropriation. The municipality must have an audit of its financial records annually. As you know, this became an issue. We'll talk more about that as well. And that audit and other financial information must be filed annually with the comptroller's office, or as has happened now to Dalton, the comptroller has the ability to force an audit of the financial records. Now, on that point, if you go to the comptroller's office and you look under on their website under the municipal division, there are literally hundreds of municipalities across the state of Illinois who have not filed the necessary financial documents, whether it's the financial report, whether it's the audit, and some of these delinquencies go back years. But soon after we had our report in early August of last year, the comptroller's office suddenly paid attention to the village of Dalton and took notice, while other municipalities across the state have been delinquent in their responsibilities for years. One might ask, why is that so? Next slide. One of the challenges, and we recommend, this is one of our recommendations, is the village doesn't have a codified municipal code. And what this means is the resolutions, the ordinances that are the backbone of governance for the village are not assembled in one location, filed with the state, so that all of you can look up what's the code say on this, that, or the other thing. This became something that we learned early on was a little bit of a surprise, but became another challenge to overcome in making sure that we had a true picture of what the rules and laws were that had been passed that govern the village of Dalton. As a result, these are the absence of archived ordinances and resolutions not being read in public led to gaps in our understanding about the laws, making governance unnecessarily difficult. Next slide. One thing, given what you've heard and seen over the course of the last couple of years, the village actually does have a purchasing policy and manual. And it's very straightforward, as you might expect. The challenge has been, it hasn't been followed, and we'll get into details about that. But let me give you a little specifics. The policy essentially provides directions for the acquisition of all goods and services. And when used with good judgment and common sense, as it reads, the quote, the policies and procedures conveyed within will allow the village to obtain required supplies and services efficiently and economically. The policy also provides, in general, all supplies, materials, equipment, contractual and professional services required for operational efficiency will have been included in the annual budget. Next slide. There is in this purchasing policy set controls on who can authorize what at what dollar levels. As you can see from this slide, department heads can authorize spending up to $1,000. Between $1,001 and $5,000, the village administrator can approve. And over $5,000, any expenses for goods or services over that amount must be brought to the village board for approval as set forth in the purchasing policy. The finance department is supposed to have a position called the staff accountant. That person is responsible for centralizing and overseeing the purchase of goods and services for the village, and to determine whether or not an item proposed to be spent, that there are adequate funds and proper purchasing procedures have been followed before any monies of the village are incurred. That person is supposed to be reviewing and initiating all purchase orders, payment requests after they are submitted to the finance department for payment. There's supposed to be centralized purchasing. That makes sense because in best practices, you want to make sure that there's not what we call rogue spending going on, and that the village is getting the benefit of its bargain by maximizing its buying power. The purchasing policy specifically says that those items are supposed to be uniformly purchased by the purchasing agent. And the purchasing policy also requires the use of purchase orders. Those are essentially requisitions for goods and services, and it's detailed there. Similarly, the purchasing policy requires that when a purchase order is issued, it has the same authorization requirements as other matters. 1,000 by department heads, 5,000 by, up to 5,000 by the village administrator. Anything over 5,000 has to come before the board for approval. Now, just to give you a little bit of context, because we're using this term as we go forward in this presentation, there's something called a warrant that is used that also dictates how municipal funds are spent. The warrant is typically created based upon invoices that are created by a vendor and submitted to the department head for approval. As we told you in August, there is no electronic process for the submission of invoices from vendors. Paper copies, typically sent either in by hand or by email, are sent to department heads for approval. They must then list them in an electronic payment system called My Viewpoint, and then that generates the items that appear on the warrant list. Based upon our investigation, there are essentially two kinds of warrant lists. There's an accounts payable warrant list, which includes most of the village's expenses, and then there's a second warrant list, that's called the electronic list, which includes payments made by wire, ACH, credit card, or any other electronic or online method. The village expenditures, as reflected on the warrant list, are then reviewed and approved by the board at each board meeting. And after an expense is approved by the board, Janice Johnson, who's Director of Administrative Services, is supposed to prepare a check for signature and payment. However, if Ms. Johnson is directed by Mayor Henyard or someone else, or there are insufficient funds to pay the item on the warrant list, then those checks are held. And apart from payroll, the accounts payable warrant list reflects invoices that have been submitted for approval and payment but not yet paid. And we understand from the John Kasparic accounting firm, which is essentially the outside firm for the Village of Dalton, that there are many items that appear on the electronic warrant list that have already been approved before they are presented to the board. Now, next slide. As it relates to credit card expenditures, we also understand from John Kasparic personnel that credit card balance is paid as a matter of course, meaning that as the bill becomes due, it's paid before it reaches the board for approval. In general, credit card expenses are only added to the warrant list when there's a receipt submitted. What we found is that many credit card expenditures never make it onto the warrant list for approval, in part because there is not a system for ensuring that there are receipts for the various credit card purchases. And what this means, unfortunately, is that the Board of Trustees, in many instances, was not able to even track or see credit card purchases that were being done over the last few years. Let's give a little background on Mayor Tiffany Henyard. As many of you know, she's a lifelong resident of the village. She served as a village trustee from 2013 to 2021. Her bio cites that she graduated from Robert Morris College, although we were unable to verify that. And she became mayor as of May 2021. Now, keep in mind, folks, there were two elections. There was an election at the end of February that went to a runoff, and then there was a final election later that spring. At the time of that second election, according to records provided to us by the County Clerk's Board of Elections, only 9.5% of registered voters in Dalton came out to vote. To set the framework further, we wanted to make sure you understood who were the people in charge of making various decisions under Mayor Henyard's administration. Aside from Mayor Henyard was the village administrator. You may recall that that was initially Dorothy Brown. And then in late 2021, Keith Freeman began his duties as the village administrator. The director of finance, you would think this is a very key position. Unfortunately, what we found over the course of our investigation is there are many periods of time during Mayor Henyard's tenure where that position was vacant. At one point, Tangier Miller fulfilled the role sometime in 2022 on a full-time basis, and then she went to a part-time basis by December of 2023 and worked only remotely. The position has been vacant, again, since early 2024. As I mentioned before, the Director of Administration is Janice Johnson, and you remember from my discussion about the purchasing policy, where there's supposed to be somebody who's a staff accountant that is responsible for monitoring and overseeing the purchase of goods and services on behalf of the village. There's no such position that exists in the village of Dalton. As a result of the small staff in managing the city finances, the John Kasparic firm has essentially become the in-house although they're outside, but the in-house financial department for the village of Dalton. Because of a limited number of personnel, they became the de facto finance department. This remains true to this day. Kasparic firm is a junior staffer who is embedded in the village, and that person is here multiple times a week. There's a senior person that oversees that junior staffer, and the John Kasparic firm is involved in virtually every aspect of the finances of the village. Reconciling bank records, assisting in the preparation of payroll, creating those monthly warrant lists, village accounting records, as well as a variety of other expenses. And as you might imagine, ladies and gentlemen, that kind of work, day in and day out, month after month, is not cheap. So the village is paying an extraordinary amount for outside services because it doesn't have the staff internally to do that. And in the absence of director of finance, without the board of trustees being directly involved, there's very little oversight over the work that's being done on your behalf. Now, I want to also now shift gears and talk about some key events that have led to some of the financial crises that the village is experiencing. And what we found in our investigation, and that's based on a review of contemporaneous documents and witness interviews, that beginning at least as early as late 2021, there was a concerted, systematic effort on behalf of Mayor Henyard and others in her administration to hide the true financial condition of the village of Dalton from the trustees and from members of the public. To step back, let's talk about what the state of play was before Mayor Henyard became mayor. What we found is that prior to that time, the Kasparic firm would provide 3 different and important categories of information to the entire board of trustees, key city personnel, to make sure that folks were up to speed on a real-time basis as to what the circumstances were, both of expenses and revenue, and whether or not the expenses and revenue were on track with budget projections. They created a weekly report reflecting what work they did on behalf of the village. Monthly financial statements with the detailed notes memorized in an accompanying memo. Warrant lists, which detailed the expenditures to be presented at board meetings. And for a time, Kasparic firm also prepared and shared a payroll list. Now, initially, in 2021, at the beginning of Mayor Henyard's term, Chris Marabali of the Kasparic firm caused these documents to be sent to a wide array of people on an email. Again, the trustees, key city employees, and Mayor Henyard herself. But this practice began to change in the fall of 2021. What we see in the fall of 2021 is the start of the effort to make sure that the trustees did not have full access to information about the true financial condition of the village's finances. And I want to walk you through step-by-step evidence that we were able to review that was memorialized contemporaneously, primarily in emails. In September 28, 2021, in an email to John Kasparic, Chris Marabali, remember this guy who's responsible for supervising the work here at Dalton, noted, quote, "The mayor has requested that the warrant list for both electronic and regular billing be sent to her first for review and approval prior to it being released to the board." On October 4th, 2021, Trustee House emailed Marabali seeking missing payroll reports that he had not received since the August 27, 2021 payroll. That same day, Marabali forwarded that email from Trustee House to Mayor Henyard and sought advice on how to respond. On October 21st, 2021, Chris Marabali reported to John Kasparic via email that Mayor Henyard was very upset with him because he disclosed in a board meeting that she had directed him not to send trustees payroll records. There's a board meeting that precedes this October 21st date, where you can see on the YouTube video that she's asking him, did I tell you not to send this information? He answered in the affirmative, and then that was a source of her anger with him. He was later called into a meeting with the mayor in the presence of Janice Johnson and Dorothy Brown, and the mayor in effect told him that he should never contradict her in public and that he should shade the truth. By November of 2021, a split between Henyard and certain trustees was in full bloom and played out in the trustees' shrinking access to village financial information. And on January 22nd, 2022, Mayor Bali again transmitted the December financials and a corresponding memo to the full list, including the trustees. But by February 9th, Trustee Steve sent an email to Mayor Bali and others objecting to not having received payroll reports for approval and saying that he would not provide his consent for approval by the board if he did not receive those payroll records ahead of time. Trustee House concurred in that same email chain. On February 24th, and this is an important date, Mayor Bali transmitted the January financials and the accompanying Miller only to Tanjani Miller. At that point, the trustees were cut out. On March 9th, 2022, Mayor Bali sent his weekly report to the mayor, trustees, and others. The next day, Freeman admonished Mayor Bali and said, quote, Chris, please stop sending these emails to everyone. It is a direct violation of the Open Meetings Act. Send this information to Ms. Miller and Janice, meaning Janice Johnson, end quote. I can tell you that the mere transmittal of information where there's no actual action being taken is not a violation of the Open Meetings Act. So in sum, by March 2022, the trustees were effectively cut off from receiving regular financial reports generated by the Kasperic firm, which would have provided them with information on the true financial condition of the village, and they would have been able to see at that point that there was a significant increase in expenses, as we reported previously, while at the same time, there was not revenue to match those expenses. Now I want to shift gear and talk to you a little bit about FOIA. Now, this is not a FOIA class. I'm not going to go in chapter and verse. But the bottom line, as many of you know, is that under Illinois law, municipalities are required to keep and produce the records of governance to anybody who asks for them with a narrow set of exceptions. And that means that the municipality has to set up a process by which people who want certain kinds of information can get that information, and that they have a certain timeline in which they have to provide that information. They can ask for an extension of time, but what they cannot do is simply ignore requests coming in through the Freedom of Information Act. Now, from May 21st, from May of 2021 through September of 2023, based on our review of relevant FOIA records and witness testimony, there were a significant number of FOIA requests that came into the village. Most of these requests were ordinary type. People asking about particular addresses within the village, people seeking other information. But what we started to see in 21, and then it increased steadily over time, is people asking very specific information about the governance of the village, and in particular, asking information about how money was being spent. At the beginning of Mayor Henyard's tenure, Clerk Allison Key was responsible for FOIA requests. According to Clerk Key, when a FOIA request would come in, she and her team would review it, then they would send it to the relevant department that were FOIA liaisons in each department, and it was their responsibility to look for responsive documents and then provide them to Clerk Key so that she could respond to the FOIA. The increased number of FOIAs over time posed a challenge given the limited resources that were devoted to FOIA. So what we saw is a very small staff, very few resources, and an expanding number of FOIAs that came in. There were not sufficient resources to be able to meet that rising interest in the governance of the Village of Dalton. Now, there were many allegations that we received that Mayor Henyard ordered village personnel to simply stop responding to FOIA. We were not able to verify those allegations, in part because village employees who reported directly to Mayor Henyard did not cooperate in our investigation. However, in April of 2023, trustees passed an ordinance intended to get the FOIA process back on track. And that ordinance read in part, quote, whereas the Board of Trustees finds that the village has experienced an insurmountable backlog of FOIA requests due to failures of village staff to respond to requests for information from the FOIA officer at the instruction of the mayor and her village administrator. The trustees obviously believe that that's precisely what had happened, which is that the mayor had instructed people within the departments not to respond to FOIAs. Now, despite the passage of this ordinance, the FOIA process didn't improve. And in fact, it continued to break down the non-cooperation of village staff, and many of whom simply, according to Clerk Key, simply stopped responding to her when she would send them FOIAs. And as a result, you know what's happened. Some of you, I'm sure, experienced it directly when you filed FOIAs. There were appeals made to the Attorney General. In some instances, people simply filed suit. Now, one key milestone that I want to bring to your attention is when Clerk Key was stripped of her jurisdiction over FOIA. As you can see from the screen, she received an email from Keith Freeman on September 7th, 2023. And in this email, I'll read the body of it. Dear Clerk Key, I am writing to inform you that you are hereby removed from your duty as a FOIA officer effective immediately. Your inability to process FOIA requests in a complete and timely manner has left us no choice but to restructure our process going forward. The village has redirected FOIA officer duties to another party, and as such, your services are no longer needed. I have advised all department heads of the change. Now, I want to be clear that Clerk Key denies the various allegations in Freeman's email. But I want to lift up a couple things that I think are notable about this email in particular. When you see the language, the village has redirected FOIA officer duties to another party. Note in this email, he doesn't say who that other party is. And what we know from our investigation is that we were never able to determine who that person was that's actually handling FOIA and whether or not that person received the proper training. FOIA is not easy. There's a lot of nuances that are involved in the statute to make sure that there's proper compliance. We have no idea to this day whether or not the person or person who was handling FOIA actually received proper training. There was no effort to take over the files of pending FOIA requests, and there was no process put in place for transitioning of the responsibilities from Clerk Key and her team to the unknown new FOIA officer. There's plenty of evidence, and again, I think you all have experienced it firsthand, that after Clerk Key was removed of her responsibilities over FOIA, the FOIA process didn't get better. If anything, it got worse. And these issues continue to this day. Now, let's shift gears, and we're going to talk about financial management concerns. There was an opportunity for the Village of Dalton to take advantage of a $5 million appropriation that had been put in place from one of the state legislatures on behalf of the Village of Dalton. This was in the state fiscal year 2023. However, that appropriation, for some reason that we were not able to ascertain, was never taken advantage of. Meaning, those monies never came into the Village of Dalton. So, $5 million that could have significantly helped the financial fortunes of this village got recycled and went elsewhere, but never came to the Village of Dalton. I want to talk to you next about the American Rescue Plan dollars and funding that came to the Village of Dalton. As many of you know, the American Rescue Plan was put into place by the Biden-Harris administration to help municipalities, cities, counties, states recover from the economic impact of the COVID-19 pandemic. And the village received an allocation through the state, which is appropriated in 2 tranches from the Illinois Comptroller's Office. You can see in this chart, the first tranche came in September of 2021, and the next big tranche came again in September of 22 for a total of just over $3 million. The U.S. Treasury Department had very strict reporting requirements on how municipal governments use those ARPA dollars. Somebody was supposed to be designated as the ARPA reporting person responsible for making sure that they were complying with U.S. Treasury regulations. But the contemporaneous documentation that we have seen and confirmed in recent communications is that no one from the village actually took the responsibility to complete the reporting information. The access to the reporting portal was set up for Ms. Miller, the former finance director, but there's no evidence that she actually made the required reporting of how ARPA dollars were used here in the village. And based on the records that we have seen, there's approximately $1.7 million left of the ARPA funds, and it's held in a specific capital projects account. Based on what we've seen in the financial documents, the ARPA funds were used in a variety of ways, which you can see from this chart. As you noted, there's a big category of $481,379 called other expenses. This was used for a variety of different things, from construction materials and supplies, lawn care, pest control, utilities, sprinkler installation, but none of these things were specifically approved by the board. Now, at this time, I'm going to turn it over to my colleague, Amanda Kite, who's going to walk you through some more detailed information on the financial status as of October 31st, 2024.
So now we're going to walk through and largely provide an update to the financial information that was presented back in August. And we've been provided records that cover the first 6 months of the village's fiscal year 2025. As of October 2024, the village's general fund, which is the fund that's used to account for the majority of the village's operations, remains in a net deficit position. However, the deficit position has decreased or improved from the information that was presented in August. And as of October 2024, the general fund's net deficit position is currently $2.4 million. Additionally, during the first 6 months of fiscal year 2025, the average monthly expenditures of the village have also decreased. Through fiscal year 2024, the village was spending on average $2.5 million per month. During the first 6 months of fiscal year 2025, that number is down to $2.1 million per month on average. Following along with that,
I think it's also important to note that when we provided an update back in August of last year, which laid out many of these numbers and showed the village in really dire financial condition, the trustees immediately took action to address particularly the spending side of the ledger, significantly reducing the number of credit card access, working with banks, restructuring some of the expenses. So that accounts in part for the reduction in expenses. And as Amanda will explain, there are other factors that contributed to this, but I wanted to note that the trustees heeded the concerns that we raised back in August and took specific action, many times in opposition from Mayor Henyard, to make sure that they were starting the process of putting the village back on better financial footing.
so following along with that, the decrease in expenditures, during the first 6 months of fiscal year 2025, the village's expenditures have matched the revenues that came in during that time period. This is in comparison with the same time period in fiscal year 2024, where the gap in revenue to expenditures was almost $5 million. So the expenditure and revenue gap has improved. This gap decrease is for two primary reasons. First being, as of October fiscal 2025, revenues are approximately $3 million more than compared to the same time period in fiscal year 2024, which is largely due to the timing of when the property taxes were released to the village. In 2023 and 2024, property taxes weren't released until November or December, where in fiscal 2025, they were released much earlier. But additionally, expenditures have gone down, most notably general administration, police department expenditures, and public works. A couple of categories that we found significant decreases is in general administration, telephone, and miscellaneous expenditures, as well as in police department overtime and medical insurance. The village's cash balance has remained generally the same since the information that was presented in August. As you can see from the chart, as of May 2024, the general fund had an unrestricted cash deficit of almost $5.7 million. As of October 24, that amount is a deficit of around $5.5 million. And this deficit includes the amount of held checks that the mayor discussed previously. Those are reflected in these deficit balances. Regarding those held checks, as we presented in August, since March of 2023, and nearly every month since then, a portion of the checks that were approved and printed have had to be held. As of June 18, 2024, this was 589 checks that totaled over $6 million, which were approved but had not yet been sent to vendors. Since the August presentation, we've requested but had not been provided an updated listing of the current status of the village's held checks. However, we've been told, though not able to verify, that the current amount is still in excess of $5 million. Turning now to discuss the village's use of credit cards. As we discussed in the August presentation, we're aware of 6 different credit cards that have been in use by the village at various points in time from January 2021 through at least June of 2024. Since the August presentation, we did request updated credit card statements that would cover July 2024 through December 2024, but we did not receive any updated credit card records. As you can see from the chart, the use of credit cards steadily increased from calendar year 2021 through 2023. In 2023, the village spent over $775,000 on credit cards. As the mayor earlier discussed, oftentimes credit card expenditures have no accompanying receipts. And this credit card statements alone provide limited information about the credit card purchases. Given this overall lack of available documentation, it is not possible for us to ascertain important information about the village's credit card use, such as who made the purchase, was it an approved purchase, and what was the government purpose. This type of additional information is necessary to perform a complete investigation of the credit card use and to draw any conclusion about any individual purchase. That being said, through our investigation, we did identify certain categories of expenses that stand out, which the village may wish to pursue additional information to further understand the nature of the charges. For example, from 2021 through June of 2024, village credit cards were used for over $171,000 in travel-related costs. Things such as airfare, excess baggage fees, hotels, meals, rental cars. There are over $51,000 spent at local area restaurants, as well as expenditures at retailers such as Dick's Sporting Goods, Best Buy, Wayfair, Walgreens, Apple, and Walmart. Now, not all, some of these expenditures, but not all, are reflected on the electronic warrant lists that we were provided and reviewed. However, the level of detail in the description of what the purchase is for varies by purchase. Some purchases have very limited information, and the description is simply the name of the merchant, or a more vague description such as meals or donuts. Others provide more information, such as training accommodations or code enforcement lunch. One area of our investigation where we were able to obtain detailed purchase information relates to Amazon purchases. The vast majority of purchases made by the village on Amazon were paid for with village credit cards. From January 2021 through June of 2024, the village spent approximately $218,000 on purchase from Amazon using village credit cards, the largest spending of which occurred in 2023. Now, the vast majority of the purchases on Amazon do appear to be for routine items such as office supplies, office furniture, and supplies for the police department. And the Amazon order details show that these orders were delivered either to Village Hall or to the police department. Additionally, many of the largest purchases on Amazon, 3 of which we identified in the August presentation, were related to materials or supplies for the skating rink. This includes $5,099 for artificial ice tiles, $33,000 for artificial ice tiles, $5,600 artificial ice tiles, $4,700 artificial ice tiles, and then $3,700 for ice skates.
Ladies and gentlemen, let me just pick up and conclude on the Amazon purchases. The various routine office supply and office furniture purchases simply do not appear to be in compliance with the village's purchasing policy as we described. There appears to be no centralized purchasing or inventory control as required in the purchasing policy. So while we were able to see that these various purchases were delivered either to Village Hall or to the police department, there is no tracking system for what happened to them after they arrived here. And while Janice Johnson was listed as the originator for a number of these purchases, what we saw in the Amazon records is that there were 9 other purchasing sources identified in the Amazon records. So lots of people were billing, charging things and purchasing them from Amazon. And we similarly found no evidence of the purchases related to the ice rink that were done in 5 separate purchases totaling approximately $48,000, that they were done consistent with the purchasing policy either. For example, we were unable to find evidence that these purchases were done as a result of competitive bidding process, which an amount of that size would have been triggered by the purchasing policy, nor is there evidence that these particular purchases were presented to the board prior to approval. As you will see, one of the recommendations that we're making to the board is to institute a written policy for performing background checks of prospective village senior and key personnel. There are 3 personnel that we call out on the slide, and based on our investigation, these and other individuals either working for the village or proposed by Mayor Henyard to assume key roles have issues in their background that likely would be disqualifying if they had been properly vetted. Now, I want to go through some of the consequences, because of course there has been consequences of all the things that we've already talked about. You can't have a situation where there are no financial controls, where the trustees are systematically excluded from finding out the true nature of the financial condition of the village, where there's a routine process of exceeding the amounts of revenue with expenses, some of which may or may not be for a legitimate government purpose. The first of these cascading consequences is the audit. As I noted at the beginning of this presentation, under Illinois law, every municipality over a certain size is required to have a financial audit of its books and records every single year, and to produce that audit to the comptroller's office. The fact of the matter is that for the last several years, the village's auditor had been an accounting firm, an auditing firm known as Lauterbach and Ahmed. Draft audits for fiscal year 2022 were completed, but they were never finalized. And then Lauterbach and Ahmed resigned as auditor on October 27, 2024, effective immediately, which is essentially less than 3 weeks after we had our first public disclosure of the true financial condition of the village. And on October 15, 2024, the Illinois Comptroller's Office notified the village that it was going to force an audit on the village for not complying with the mandatory audit reporting requirement. Now, as I noted, there are literally hundreds of municipalities across this state that have long-standing delinquencies in filing their reports. But for some reason, the comptroller decided that Dalton was going to be the example. Next slide. One of the other consequences that we've seen over the course of Mayor Henyard's tenure is a significant uptick in litigation. According to court records maintained by the Legislative Council, 48 separate lawsuits have been filed against the village under Mayor Henyard's tenure. 12 pending matters relate to FOIA violations, and 8 pending matters by village vendors allege improper revocation or failure to renew business licenses. And you may have seen recent reporting that on Friday, Mayor Henyard herself was held in criminal contempt for failing to sign a liquor license for an existing business owner here in the village, despite being ordered by the court to do so multiple times. Those have costs. Next, I want to walk you through the insurance issue, because insurance is a significant cost in the budget for the village of Dalton. The village's insurance fees are primarily handled by 2 entities: an insurance broker, which is Insurer Source LLC, and something called a third-party administrator, which currently is Charles Taylor, TPA. In 2024, the village's insurance coverage became at risk due to late or non-payment of fees. The village's premium financing company sought to avoid its contract with the village. And let me explain what that means. There is a finance company that fronts the money for the village's various insurance costs, and the village pays it back on a monthly basis. But because of non-payment, that finance company walked away from its responsibilities and said, we're not going to we're not going to finance any future funds to the village to pay its insurance. That created a bit of a crisis. The village's longtime third-party administrator. That's the entity that then pays claims that are made by people that trigger the insurance policies. That third-party administrator also walked away and refused to renew its agreement with the village, again, as a result of problems in payment. And then longtime insurance carriers. The village had, like most municipalities, has multiple insurance carriers that cover their insurance, particularly liability insurance. Many of those longtime carriers canceled in the spring of 2024 or declined to renew the village's policies. Next slide. Now, this came at a critical time. The renewal period for village insurance is early August of every year. Typically 60 days before that time, the insurance broker will start negotiating, renewing terms of coverage with the various insurers. You had the TPA walk away, which is known to the insurance companies covering the village. You had the finance company walk away, which is known to the village. And the fact that these other carriers decided not to renew, that also sent a ripple through the insurance market. As a result of the efforts of the insurance broker, he reached out to 36 different insurers, including 10 excess insurers and then 26 non-excess carriers. 5 carriers chose not to renew their coverage for the village. 13 carriers declined to quote coverage for the village, meaning they weren't even interested in providing a quote. And 1 carrier simply didn't respond. And of the excess carriers who provided a quote, they set their threshold for coverage very, very high. 2 set it at 25 million, 4 set it at 10, and 2 at 5, and 1 declined, again, to quote any coverage. Now, the village was eventually able to obtain coverage for the 2024-25 period. However, there were 2 important concessions that the village was compelled to make in order to make sure that it had insurance coverage from August of 2024 to August of 2025. As you can see from this slide, the village was compelled to pay more for less coverage. We have here a kind of side-by-side comparison of what the coverage was under general liability, law enforcement, public official, and auto liability. In the preceding year, the coverages were almost equal at $11 million. But as you can see, in the current coverage period, there's a significant decrease in the amount of insurance coverage that the village now has to handle whatever liability issues may come up. The other significant concession was that the insurance carriers refused to cover Mayor Henyard. As you can see in the third bullet, there's a quote directly from the insurance policy. The insurer covers all elected officials, provides that as a separate part of its coverage, but specifically in writing excluded any claim made against any insured which is brought by, on behalf of, or against the following entities or individuals, and that is Tiffany Payment. And the emphasis here was in the original. This coverage exclusion regarding Mayor Henyard also applied not only to the general liability policy, but also the law enforcement policy. Now, there are implications for the village given the cancellation of coverage for Mayor Henyard during this coverage period. Mayor Henyard will have to pay for all defensive costs related to her out of pocket, or the village could decide on its own to pay for her coverage, but it won't be covered by the insurance carriers. Now, Mayor Henyard would then be responsible for any judgments, settlements, or attorney's fees rendered against her personally, separate from the village. And there's an open question as to whether or not Mayor Henyard will participate in litigation that she has to pay for herself, and what that would mean for the village if she simply defaults, meaning doesn't show up, doesn't participate in ongoing litigation. So the absence of coverage has significant implications for the village and for the taxpayers of the village adult. Other implications. The fire department. After 2 years with no resolution of a contract, finally in the fall of 2024, Legislative Council was able to reach a collective bargaining agreement with the fire department union, which a majority of the board approved over Mayor Henyard's objections. The village is currently in negotiations with the police department, but the challenge with that, negotiating that contract, is without audited financial statements. And you remember we said there's been no audit of the financial statements since fiscal year 2021. It's difficult for village negotiators to be able to project what revenues are going to be coming in so they know what a fair salary and compensation would be. Now, as we're winding down here, I'm going to cover quickly some other remaining items that I know are of interest to the public. And let's talk for a minute about the Las Vegas trips and the allegations against Trustee Holmes. There are actually 2 trips, one in May 22 and another in May 2023, where Mayor Henyard and a large delegation went to an economic development convention in Las Vegas. The convention was called Recon, and it was put on by the International Council of Shopping Centers. Financial records from the village and Thornton Township reflect that a number of people traveled to Las Vegas on both of these trips. And then the expenses of their travel, their lodging, their meals, and entertainment were paid for on village and township credit cards. There is no evidence that any business development opportunities came to the village as a result of either of these 2 trips. You are all aware of the fact that there were allegations against Trustee Holmes as a result of contacts between him and a former village employee on the May 2023 Las Vegas trip. We're not going to go into chapter and verse on this because we are not a criminal investigative authority, but suffice it to say, the allegations are that Holmes took advantage and assaulted a young woman while she was unconscious in his hotel room, that he contacted a village Dalton police officer who was also on the trip, FaceTimed him, showing the young woman unconscious on the hotel room, and some of you are aware that a recording of that FaceTime call has recently surfaced. The young woman eventually filed complaints in Las Vegas and suburban Cook County. Fall of last year, the Las Vegas criminal authorities closed this case after its investigation. The young woman has also filed a complaint with the EOC alleging that she was wrongfully terminated from her employment as a result of making an outcry to Mayor Henyard directly about the alleged assault. And the young woman has subsequently filed a lawsuit which makes similar allegations, and that lawsuit remains pending. Importantly, neither the young woman, Trustee Holmes, or other witnesses cooperated with our investigation. Another thing that I think is important regarding this alleged incident between Trustee Holmes and this young woman. Working through the Delgado law firm, we learned that Mayor Henyard authorized an investigation to be conducted by a firm called R.E. Walsh & Associates out of Oak Brook, Illinois. This investigation was not authorized by the board, and the results have not been shared with the board. It is unknown to this day what the scope of the investigation was, who was interviewed, if anyone, what documents were reviewed as part of this investigation or its findings. The R.E. Walsh firm has refused to provide its report or otherwise answer any questions about its investigation because it's not been paid for its services. Let's talk for a moment about Thornton Township. In the course of our investigation, we received a lot of information that there was significant use of Thornton Township funds to cover expenses for the benefit of the village adult. Similar to the lack of cooperation in the village, personnel under the control of Mayor Supervisor Henyard, we faced obstacles obtaining documents from Portland Township. We therefore are not suggesting we do not have a complete picture of a variety of the allegations against Mayor Henyard and others in connection with the operation of the township. Nonetheless, we received some information to determine that a similar pattern of financial operations existed at the township during Mayor Henyard's tenure. For example, credit card abuse. We were able to review records from May of 22 through October of 22, June of 23, January of 23 through June of 23, and January of 24 through June of 24. Obviously, not a complete set, but detailed records. Some of these records, excuse me, were heavily redacted. They look like the CIA took the documents through their censors. So it made analysis somewhat difficult. But we were able to decipher some of the records. There were multiple credit cards in use in Thornton Township, and the names of township employees specifically, such as Tony Sherman, Keith Freeman, Shelley Miles, Robert Hunt, Marsha Walker Brown, Tanika Hughes, William Moore, and others. In 2024, for example, based on those 6 months of records, monthly charges range from $88,000 a month to over $100,000 in many of those months. And there were a significant number of food purchases and other expenditures that frankly warrant further investigation as to whether or not there was legitimate government purpose for those expenses. There was overlapping hiring and firing of township personnel. A number of witnesses that we interviewed indicated that within months of Tiffany Henyard becoming supervisor on March 3rd, 2022, a number of longstanding employees lost their jobs. We heard many allegations about political retaliation, cronyism, and that people were let go because they questioned the seeming elimination of hiring and purchasing norms. Efforts to verify these allegations, principally through FOIA requests, did not bear fruit, as the township often claimed no responsive documents or failed to address specific FOIAs. We know that Henyard hired her boyfriend, Kamal Woods, to run a township youth program. His personnel file, such as it is, contain very little information to justify this hire. Tanika Henyard also became an employee of the township. And Henyard installed her former administrative assistant, Carmen Carlisle, to fill a vacancy left by the death of a long-standing trustee. We received information of various allegations of political retaliation. You are all, by this point, well aware of Henyard's treatment of Township Assessor Cassandra Elston that included locking Elston out of township offices and then later accusing Elston of abandoning her job. All of those things is well documented. We won't go into details. We were able to verify that longtime township employee Dwayne Thrash has alleged in a lawsuit that he was fired from his job, not because of competence or insubordination issues, as were later put into his personnel file, but because he refused efforts by Henyard and Freeman to agree to a plan to effectively let Henyard take control of a local suburban school district on which Thrash was one of 3 members. The alleged plan included creating a paid employee role for Henyard, firing other employees, and terminating the relationship with an existing law firm and instead installing Henyard's chosen law firm. Can you guess? Thrash alleges that he would not agree to the plan and subsequently lost his Thornton Township employment in retaliation. Now, we have a number of recommendations that we are making to the trustees. I'm not going to spend time tonight going through those. The trustees have them. But suffice it to say, there are obvious things related to finance. There are obvious things related to personnel. And some of these things, as I indicated, the trustees have already started to embrace and implement, particularly with respect to putting guardrails around the finances of the village. And with that, we will close. Thank you for your time and attention. Now, to say at the outset, we have passed out index cards. If you have questions written on them, pass them forward, and we will entertain some questions. Can members of the Park District staff perhaps help us collect some of these cards and bring them forward? If you have a card, hold it up in the air, and somebody will come by. Maybe pass them forward to the front. That's probably the easiest thing to do. And remember, if you'd like an electronic copy of this PowerPoint deck, please make sure you provide your name and your email address. Come on up, man. If you've got questions, please pass up your index card. We'll try to get to as many as we possibly can. All right, we have a couple of questions. One is, why didn't the $5 million come to Dalton? The answer is we don't know. What happens is monies get appropriated and become part of a budget. It will go to the relevant state department for allocation, but then the municipality has to fill out certain paperwork in order for it to claim that allocation. We have not found any evidence that that happened with the Village of Dalton. This person also asked, is there anything to hold Tiffany personally liable? Well, as you know, there are a number of different lawsuits that have been filed, and obviously you have your vote. Next question is, if supervisor is uninsurable, how can she hold a position? Now, the insurance issue is with respect to her role as the mayor of the Village of Dalton. We have no visibility into whether or not the insurance issue also applies to the township. But she can still hold her position, but as I indicated, with a lack of insurance coverage, it puts the village and the taxpayers potentially at risk. And certainly she would have to pay for her own lawyer, her own defense, if she is sued in the course of her duties. There's a question of who pays the services that are rendered by my colleague and I. As you recall, the trustees voted to approve the hiring of us, and that comes from the Village of Dalton. Are you bringing me one more question in? Come on. That's right. Okay. There's a question of whether the village will be able to get federal or state funding to bail us out of this mess. And the answer is, I think that's a matter that the trustees are actively pursuing. There's a question, have all of your findings been given to the FBI and any agency concerned? Maybe we all turn and wave to our friends in the federal government who are surely watching this live stream. What I will say is we have been in contact with members of the U.S. Attorney's Office who are investigating this matter. I know that The FBI has also been in contact with various people who have information about the allegations are here, what they intend to do and the timing of that. No one really knows except for them. Just sort through and see if there are any other questions. Someone asked if the $5 million grant was a mismanagement or theft, that we did not get it. As I mentioned before, there's a process by which a municipality that gets an appropriation has to claim it. There's no evidence that that process was followed. There's a question of when can vendors expect past due payments to be handled. I'm aware that the trustees are working diligently to try to work through the number of vendors who are owed goods and resources, but recognizing that village resources are tight. There's a question of how much money is owed to credit cards. I think we covered some of that in our report. The trustees have substantially cut down access to credit cards, so we expect credit card spending to go down. Most of the payments were made and the balances paid in total at the time that they were incurred. And there's a second question, is TIFFANY going to be held responsible to repay the money spent on the ice cream? That's a very good question to which we don't have the answer. Okay, all right, we've got the final 3 questions. All right, actually, final question. The others were requested to get a copy of the PowerPoint deck. How many laws have been broken? Good question, but impossible to quantify. Thank you all. Thank you all for your time and attention.
Okay, we want to thank everybody for coming out, and on behalf of the Dalton residents, Board of Trustees, we want to ask everybody to give a round of applause to Mayor Lightfoot. We were working diligently. This has been very critical for us to start to get a picture of what's going on so we can begin working on that. So Mayor Lightfoot's influence has really been tremendous on us getting on the right path.
You know, one thing that I wanted to make sure that I mentioned, there were a significant number of folks that didn't cooperate in this investigation either because they were scared or they chose not to. And there were some people who didn't cooperate initially, but then I'll say saw the light and did. And I want to call out one of those people was Keefie, the administrator. He was definitely Team Henyard early on and wasn't particularly cooperative, but sometime late last summer, clearly had a change of heart, and it's been very instrumental in making sure that we got access to the financial records that were critical for us to be able to provide this information to you. So I just want you to keep that in mind. Thank you, Mr. Freeman, for what he has done to work with the trustees and legislative council to make sure that there was more transparency, particularly around financial matters for the village. Thank you all, and good night.
Welcome, everybody. I'm sorry we have to be here. I'm Congressman Dan Goldman from New York City. We are here following Donald Trump's pardoning of more than 1,500 convicted criminals who stormed the Capitol on January 6, 2021, violently attacked
Mm. Well, people, let me go right on along. Lord have mercy. I had to put that late minute ad on now. And it gave me a chance just in time to make and eat a BLT. Yes, ma'am. And I got another one right here in the little wrapping right here. Just in case I'm gonna roll on over in the middle of the night. Might need to put a little more mayonnaise on it. A little more mayonnaise. Ain't that crazy? Lord, I was like, okay. I didn't know prior to me just Googling Lori Lightfoot's resume, right? And I'm like, okay. Now, it's the difference between someone breaking down something that they've committed from reading. There's a difference between somebody breaking down something that they've done the research on, and there's a difference between somebody breaking down something that they've actually worked it, you know? And I could tell that she worked it. So I'm like, okay, I didn't know if, I just thought, she was a politician from Chicago. I didn't know. I didn't know she was a lawyer and worked at. I was like, this seems too familiar. This is too familiar. But she's saying how she's doing it, whatever. Let me go look. Just like a lot of times when I see people who's um, like I may believe that's a Virgo, I may believe that's a Leo, because those are the two signs I'm more familiar with, and I go look, and I'm like, oh yeah, one type thing, your people. Baby, oh Tiffany, honey, I wonder if she's trying to pack to go on, get on up out of this country or whatever, child. That is crazy. And it's almost, and here's the thing, right? If she was ever charged, if they wanted to be nasty, because the steps she took and when she started allegedly, I'm gonna put allegedly, started doing all this shit or whatever was almost immediately after she got in office, right? After she, and they can kind of um, incorporate in her charges that she took that position. Well, she's the is that the mayor? Is she that's the mayor, or is that the really supervisor job? I don't know which one it is, because um, well, they can set when it was premeditated, so they can determine whether she took the job with the purposes of defrauding the people, or when she got in there and saw how to do it, then she set out to defraud. They can write it up either way, right? All depends on what the evidence would show. Okay. Um, I told you, y'all, we have to be on the next level. Now I can't do the remedial. Can't do that no more. I can't do that. So we're just gonna have to. Just have to catch up. Um, and you could only prosecute someone if you can prove what the evidence will show, and that's why you hear judges admonish or make sure sometimes that prosecutors stay on track in the opening, because they're going to um, make sure they reiterate what the evidence will show, and then also the defense as well, right? You don't supposed to veer too far off the course. Just, you know. Anyway, that's crazy. Moving on. Let me get to the. Well, I can do the R. Kelly thing and I can get to the ASAP Rock. And the R. Kelly thing is not very much I want to go when it comes to that. Just want to talk about the options when it comes to where he is in his particular situation. It's not a very long. I mean, we've gone over a whole bunch of this stuff um, before he got convicted. Definitely afterwards, and then as each subsequent paper filing came out, we went over it. So, but from time to time, you will think, okay, what is his options? To me, this is my opinion. His best options are any of those programs that he may fit in, where it will allow him to get out soon. I don't know what type of first step programs, what type of medical, what type of any of those programs that he may qualify for. Always got to be on the lookout for those. There are some that may develop over time. There are some that may exist now. But in my opinion, that would be, I would think, the most reliable option. Okay, because obviously pardons and appeals and Supreme Court and all that stuff that move very slow. Okay. Um, I mean, but there's any type of programs that he may qualify for, if there's any way he can get into this program, that program, this whatever. I know the scam they run back here in Jacksonville, everybody's on crack. So they can get in a drug program and get out. I don't know if that's how they work in your state, but everybody's on crack. Everybody got some kind of something. And yeah. Like, you ain't never done dope a day in your life. Judge John, I'm on dope. Okay? So, because a lot of, those people get out, get a modification of where they do their time, how they do their time, all that type of shit. They go through the drug treatment program. And this is crazy. Go through the drug treatment program, but only level of treatment you get for drugs is some kind of counseling. Because you're not really on drugs or you never been on drugs. And then those who present more that they're actually on drugs, of course, they get like whatever the more intense, therapy, to include medicines and things of that nature. Other than that, they just get the counseling and get on about it and promise it, That's crazy. But yeah, I think the options that will help him the soonest, the quickest, and without a lot of bureaucracy and all these filings and whatever. I mean, just leave it up to good behavior, no infractions, this, that, and the third, that type of stuff, right? Stuff that he could qualify for if there's such a program. Because when it comes to his particular charges, sometimes a lot of those programs kind of exclude those types of charges, that type of behavior, right? So, but I don't know, it's worth looking into. I'm not sure. All right, but I don't know if his attorney has someone on the staff that look for those type of programs for the people they represent. Sometimes their level of representation is in and out the court, like in the courtroom and out. And when you're talking about outside the courtroom, things that's related to the case, right? When it comes to detention and things of that nature, it's helpful to have like friend or a relative or whatever on the outside looking for those particular programs, trying to figure out what's necessary, making contact with the prison um, facilitators and all of that, right? Just want to make sure that you have somebody who care on the ball on the outside that's getting it together, because they can spend the time it takes to look for all those requirements and whatever, that we can relate it to the defendant. Sometimes your lawyer don't have those type of people that can sit up there and waste those resources, right? They have other shit to do. They got to work on cases, right? So it's just an avenue. I'm not giving nobody this is no legal advice. This is no kind of help. This is not whatever. I just said what it is. We're talking about options. We do both sides, right? That's how we keep it fair and balanced. Other options, of course, are the ones that we've already spoke of. Is of course the habeas corpus, but also there is an option for pardon. Now, I don't know. I'm not saying it did or did not happen, but I don't know if someone put in a petition to buy it. I mean, it can't hurt. I didn't hear nothing about it. We don't know for sure that his attorney did, but I mean, me myself, I don't like that taking just one stab at the apple or what have you. If shit, it can't hurt, right? What my mommy say, nothing beats a fail but a try, something like that. Put in that application to buy. Okay, that didn't go. Put in that application to Trump. Putting that, just put it in. See what happens. The worst thing they could say is no. I mean, the worst thing they could say is no. Um, and then you have, of course, a habeas. Hold on for a minute. Okay. Now, with pardons, right? Now, and it's so crazy that we were going to talk about it. I don't know if that press conference will get into it, but although a president can pardon you. A pardon is not absolute power. The feds can challenge it, stating that it violates the Constitution, right? They can challenge it on constitutionality reasons, right? So it is not an absolute power. It's not a power that goes unchecked, meaning, Now, it's, and be clear, it will be, when it comes to a pardon, it would be kind of hard to violate the Constitution, but you can't pardon somebody for treason. You're not supposed to, if I'm not mistaken. But, yeah. Let me make sure. Hold on. It ain't something I do. Oh, they say you can pardon for treason. I thought you couldn't be pardoned for treason. Yeah. Okay, yeah, they said you can. Yeah, that's why I pulled up the damn thing. You can't trust that goddamn Google. You gotta pull up the actual paper. So my bad, you can't be pardoned for treason. Because, I'm thinking treason is punishable by death. It's a serious enough crime that although it doesn't necessarily require, um, doesn't necessarily have anything to do with somebody dying, but you can get a pardon for that. See how, boy? Didn't I tell you the law is contradictory? It contradicts itself. It's weird. But yeah, so you can't pardon for impeachment. That's what it says. That's crazy. Okay. Impeachment. Anyway, so, but it is not an absolute power, meaning that it can be challenged and by the feds, and it would be the Supreme Court that would make a decision if there is something that's challenged. So I don't know. I'm gonna go when I get off. I'm gonna listen to what they were getting ready to say, see if they, because apparently they seemed like they had an issue with those pardons of the January 6 people. I don't know what they getting ready to talk about, but it'll be interesting to find out. But yeah. But anyway, I'm just saying, when it comes to those pardons, I mean, I would have thought somebody would have put in an application under Biden. I don't know if it happened or not. Then you got, take a stab at Trump. Shit, hell. But, Biden was cutting the food with that pen. Shit. Biden having a good time. And they got some nerve talking about what Biden doing. He pardoned his son. He did this, whatever. Nigga, you done cut more deals, did this, than whatever, than anybody. Don't talk about no what the hell Biden doing. Are you letting loose with that? if you if you don't stop, I mean, he literally letting folks out of jail. Majority of Biden's um, pardons was commutations of sentences, and like people who had gotten convicted or whatever, like, he forgave that. Not um letting motherfuckers out and all of that. Just shut up. Oh, I don't know. I'm not gonna stay focused. I'm stop get off Trump because I get to cussing, get mad. I've been doing good. I've been doing good. Pastor Jeff would be proud of me. Woo! And we got our own pastor. But anyway, but yeah. And another thing, but along comes with pardons and and some of the other things that need some type of national um, visibility. And that's crazy. Look like to me, you should have listened to R. Kelly in some form of fashion because he was right on time when he was thinking that, yeah, he got to get some people fighting for him on social media. And he said that in that song. Why you ain't fighting for me? Now, either somebody told him something, he media trained, or he rolling with people that he got a certain type of status and whatever. So all of that shit comes with having that type of stuff. It's just, you understand what I'm saying? If you ain't a part of those circles, then you won't know what I'm talking about. That's the cycle of information that we have amongst each other. You understand what I'm saying? You got a friend that's a doctor, I'm a lawyer, this person is an accountant, whatever. We got a good conversation. We got some information going on. That one is a cop, he gonna tell us what they setting up on around the holidays. This type of shit I'm talking about, that's how that works. And it's legal. It ain't on the Martha Stewart shit. She did something else. Now, if do be some people be doing that, that's when you leave a circle. Nah, bitch. We don't want to know nothing about it. No, but I'm just being honest, right? Understand this. When you're dealing with circles of information, you can find out anything. You can get anything. That's just the game. Whether it's legal, illegal. Where you need somebody ass beat or you need somebody ass kissed. Either or, you can get it. That's just how it is. Now, I ain't saying I know nothing about it, so don't send them my way. I'm just telling you that's how it works. So R. Kelly had the right mindset when he said, "Why you ain't fighting for me on social media?" He needs a movement that will assist that party, right? Because mind you, right, it's two ways. You're gonna put in the application, put your petition in. It goes. It's kind of the setup is kind of the same way as it is for the Supreme Court. The board that screens those applications, they're the ones that pass it on to the president, unless the president acts on his own behalf, right? And know that there's, somebody, his friend or somebody, whoever in prison or whatever, got caught with some federal charges, and he's going to act on his own behalf, right? Unless you got a Kim Kardashian, you got a movement out there, whatever. You see how he did with them January 6 people. He know they still out there. He know that. I mean, I don't know if there was a movement to get them out, but he's aware. You have to have awareness. That's what advocacy brings. Awareness. You need a movement. You need something. I'm pretty sure he knows that the man is in prison. But is there a big and here's the thing, right? This could have been a missed moment, right? Lord, Trump liked uh, to attach himself to whatever the new norm is, whatever the goings on is, whatever was popping was hopping, sometimes, a lot of times. That's what he like to do. Hey, who's to say that he wouldn't, be down with some shit like that? Now I don't know if he would, but he likes to be popular. He likes to do what he think is popular. He likes to do what he think his friends want him to do. He likes favors. He likes those type of things, right? So who knows? I don't know. I don't know. But I know you don't have no visibility. You just lowering your chances, and hey, I'm a bitch like to increase her chances. That's just how things are done. Like, you can't be sitting in the back and thinking, oh, it's gonna happen. That ain't how that works. That's not how that works, right? And the last way, of course, is that habeas corpus, right? And you pretty much got one lady sitting back trying to figure out were there any legal errors that happened during his cases. Um, was there any substantive or procedural violations that violates the Constitution? Are there any constitutionality issues? And I would think that all three of those um, all three of those options, people would, put 100% behind or whatever. This is my opinion. Oh, you put 100% behind whatever you want to do. I don't care. It ain't got nothing to do with me. But what I'm saying is, whatever you do, you put 100% behind it. And I just don't rely on just one door. That's just crazy. Never was told that. Never was taught that. Never even, you know, felt like that's always a good idea. And it doesn't hurt. One doesn't cancel out the other. The timely filing and stuff like that goes on between the habeas corpus and appeals and all this stuff. That's not any consequence. I'm pretty sure she is an appellate attorney. I'm pretty sure she has she's in she has the clock. She knows she got the time limits and all of that. She got that down. So I'm just saying. Or you could just do nothing and pray it out. I don't know. That's the fourth option, I guess. But faith without works. If the super saved people say go by the Bible, you know, that's just the options. And that are viable solutions, right? Don't know if any of them will work. I ain't said none of that. I'm saying that's what people do to get people out. That's what attorneys do to get people out. That's what people that are concerned about getting your ass out, that's what they do. That's what the Innocent Project does, right? See, I'm telling you different with a regular practicing attorney that's going into court with your ass doing this, that, and the third, whatever, and you get an attorney from the Innocence Project, right? The Innocence Project, they explore all those options. They're not just dealing with your in and out of court related options. They explore every goddamn thing. Okay. They are exploring everything. And a lot of times you call them to say something else, what happened. You know. You your advocacy is strong. Attorneys have relationships with the prosecutors and so on and so forth, right? Sometimes they may agree to have you resentenced if they present a joint, you know, a joint request to the judge. It's a lot of shit that can go on. The Innocence Project, they do all of that. They don't just stick to one thing. Okay, they be trying to get your ass out by any means necessary. You know, by any means necessary. Of course, the object is to get, you know, if you're saying that you didn't kill somebody or whatever, and the evidence comes about, and or they, you know, and the evidence comes about, right? That's what people typically think the Innocent Project only focus on. The evidence comes about, and you know, you have DNA tested and blah 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 blah. They also trying to get your ass out if your rights was violated. You didn't have a fair trial. So that doesn't really goes to whether or not you did it or not. It goes to whether or not you had a fair trial. Okay? Now you gotta take from me. I ain't got nothing to do with it. I'm just telling you, I, um, you know, this is R. Kelly's sector. I'm going to always put that ahead of any other case, and I'm gonna always revisit it as if it's my case. Well, it's not. But I mean, like this is it's our case out here, so I mean, it is what it is. You know, um, movements serve so many, you know, purposes, right? And sometimes you force or it forces the law to look at itself, right? Because it's supposed to be a system of checks and balances, and people supposed to be sentenced to, fair and all of that, right? So I'm just saying. Moving on from the archery, we'll go to ASAP. Now, hopefully, I'll want to watch this tomorrow, and I can't. I hope it ain't no trial that expects to last no 4 to 6 weeks. Let me see how long this trial will last, because I don't want to jump on something and uh-uh. Let me see. Cause baby, that young dog trial. Oh, they said about 3 weeks. Oh Lord, if convicted, ASAP Rocky faces a maximum up to 24 years in prison. Baby, you should have took that. You are on the camera. You should have took that plea deal. However, he can take that plea deal before I'm just stumped right there. Huh? What was the plea? Let me see what the plea deal was. Hold on. Is this crazy? You got a baby. Let me see. Hold on, let's see if it tells us.
Opening statements have begun in the ASAP Rocky assault trial, one day after the jury was sworn in this case. And today in court, where the defense has been delivering its opening statements, prosecutors wrapped theirs up a short while ago. Earlier, the Grammy-nominated rapper entered court through a swarm of photographers and journalists. ASAP Rocky, his real name is Rakeem Myers. He faces 2 felony charges for allegedly firing a semi-automatic gun at a former friend during a 2021 confrontation. He's pleaded not guilty, and he also turned down a plea deal earlier this week. So if convicted now, he faces up to 24 years in prison. ASAP Rocky is linked romantically to Rihanna. They have 2 children together. To discuss, let's bring in ABC News legal contributor and trial attorney Brian Buckmeyer and ABC News contributor and SiriusXM radio host Mike Muse. Gentlemen, welcome. And Brian, first is ASAP Rocky's lawyers today. I guess they tried to end the case, start over after arguing that a firearms analysis report the prosecutors received shouldn't be admitted. Yeah, what's going on here?
Yeah, so when the defense shows up, they make this argument that firearm evidence, the analysis used on the shell casing, because no actual gun was recovered in this case, was turned over to them late last night into the early mornings. Prosecutors pushed back and made the argument that there's no what's called discovery violation, because while law enforcement gave it to them late, they immediately once they had it, gave it to the defense. And so the judge says no one's going to talk about this firearm analysis during the opening statements. The judge, I think, even offered to help pay for analysis for the defense so they can kind of catch up and make the arguments when they need it. But it seems like, as you said, we're starting the opening statements, even though I think the defense made a strong argument as to why this evidence should either not be in the case or at the very least try to throw out the case as it starts.
Got it. Thank you for that, Brian. And Mike, so the
Prosecutors asking the jury to use their common sense here. But I guess what's going to be key in this case is the relationship between A$AP Rocky and the victim here. How do you read how common sense works here?
That's a great question that you asked, Terry, because how do you have common sense if you may not be aware of cultural competencies when it comes to really understanding the narrative of A$AP Rocky and who we see too with A$AP Relly. As I've been talking with you, Terry, throughout these last couple of days, is the fact of lack of representation on this jury. And once the final jury got selected out of the 12, none of these jurors are Black. Now, that isn't to say that all those individuals cannot have understanding of cultural competency and can't have an understanding of hip hop and hip hop culture. But if we look at the laws of justice and that you have a jury of 12, so to be judged by your peers, one would question, is A$AP going to have the best ability to be judged fairly if there are no individuals that look like him? And so when it comes to asking the question of common sense, one has to square and say, how can we reconcile common sense when there may not be any understanding of cultural competency going forward? That is going to be something I'm going to be watching for along with this trial.
And Mike, if I can follow up on that, press you a little bit. So aren't there a lot of instances in trials, and Brian, you can jump in on this as well, where jurors are clueless, right, about the social milieu, about the vocabulary, about the technicality, if it's a business case or whatever like that. And then it's up to the lawyers to be effective in informing them and getting them up to speed on that. Does that make sense to you, Mike? What do you think?
Oh, yeah, definitely makes sense. And of course, there's going to be more trials that be more technical. And so juries have to get up to speed about. But if you look at a case that could typically have like a technical component to it, maybe dealing with like technology, artificial intelligence, software, there isn't too much of a perceived biases that come with it. Hip hop has been such a very controversial genre for such a long period of time. Terry, dating back to First Lady Nancy Reagan, when she viewed for censorship when it comes to hip hop lyrics, right? And when it comes to hip hop artists. And so hip hop has had a very antagonistic dynamic with the American public. And so there's so many individuals that comes to perceive biases that are associated with hip hop. A lot of individuals believe that hip hop is a cause for so much violence that takes place today in society. So when you bring all of those factors into it, this isn't about bringing a jury up to speed on technicality aspect of it. But what happens is we can't take away biases that are rampant throughout America and not having an understanding because of, in the language of hip hop, there's so many things of entendres, right? We have double entendres, triple entendres, right? And so what may be seemingly as one thing to the naked ear or eye isn't exactly what is actually being said and stated. And so that is what I mean by cultural competencies and the challenge of reconciling, to your question, common sense with cultural competencies.
Got it. That's very helpful. Brian, what do you think?
Yeah, so I think what Mike is getting at, I don't want to speak for him, but it's the idea that every one of the witnesses that are going to come up are going to be A$AP Rocky, A$AP Relly, A$AP this. And I think the fear is that when you hear that, you don't want to make a connection in the same way that you might, for example, when we talked about YSL, when the government was talking about YSL being a gang. No one's going to think if you say ABC's Mike Muse and ABC's Brian Buckmeyer and ABC Terry Moran that we're part of an ABC gang. No, that is the job in which we have. And I think the fear is that the affiliation of a collective of people who create music and fashion, that they may be inferred as being a part of a gang. And if that inference is there, then when there's a shooting involved, a jury might just think, you know what? They're all part of this A$AP gang. And so of course there's going to be a shooting. And I think that's the fear that people have about the lack of, as Mike put it, kind of cultural competency.
Got it. Very helpful. Brian and Mike, thanks very much. Appreciate it.
That's crazy, honey. Did you see how he pushed past them people? One at him? Oh, Lord, honey. Oh. Let me play this last article and get him up out of here. That's crazy.
Los Angeles, AP. A judge said he expects a jury will be chosen at the trial of A$AP Rocky on Thursday. while lawyers for the hip-hop star are protesting the dearth of black candidates for the panel. Nearly 100 potential jurors will pack into the Los Angeles courtroom for a third long day of questioning at the trial, where Rocky is accused of 2 counts of assault with a semi-automatic firearm for allegedly firing on a former friend in Hollywood in 2021. Opening statements will begin once 12 of them, and 4 alternates, are seated. "I'm pretty sure we're going to have a jury tomorrow," Superior Court Judge Mark Arnold said at the end of court Wednesday, thanking the panelists for their patience. "This is not going to go on forever." Other than dismissals for cause, each side can have 10 jurors dismissed without giving a reason. The defense has used 4 of its challenges. Prosecutors used just 1. They said they are happy with the jury as currently composed, but that may change. Meanwhile, lawyers for Rocky said they plan to appeal a judge's rejection of their request for a hearing on why less than 5% of the jury pool is black, while the area they are drawn from is 9% African American. It's possible that none of the 16 jurors selected will be black. "We're troubled by that, to say the least," defense lawyer Joe Tacopina said. "We're in downtown Los Angeles, not a small town in Montana." The Reverend Al Sharpton said on the social platform X that he has been following the proceedings and was critical of the racial makeup of the juror pool. "It is absolutely ridiculous that the jury will be not fair and representative, so as to deprive ASAP Rocky of a fair trial," the Post said. "I am monitoring this trial and challenging the Los Angeles District Attorney to ensure that fair and representative justice is afforded to ASAP Rocky." The judge declined to pause the trial for the appeal. Prosecutors questioned potential jurors Wednesday about their attitudes toward police and celebrity. Deputy District Attorney John Lewin asked how many of the 12 people in the jury box during the first round of questioning consider themselves fans of Rihanna, who is Rocky's longtime life partner and the mother of his 2 toddler sons. 4 said they were. He asked them whether they'll worry about the effect that convicting Rocky on 2 felony counts of assault with a semi-automatic firearm, which could lead to many years in prison, could have on Rihanna. "You put it in my head, now I'm like, oh, it would affect her," one woman in the jury box responded. Rocky, who is free on bail and has pleaded not guilty, sat at the defense table, watching the questioning. Rihanna was not in court with him, but Rocky's mother and sister sat in his section of the gallery. When told who they were, Arnold marveled at the youthful appearance of his mother, Renee Black. "What were you, 7 when you had him?" the judge asked. She said she was 26. "You are very beautiful," the judge told her. That's on the record. Jury selection began Tuesday after the 36-year-old Rocky, whose legal name is Rakim Athalaston Myers, turned down a deal offering 180 days in jail, a 7-year suspended sentence and 3 years probation if he would plead guilty to one of the 2 counts. Rocky is set to headline the Rolling Loud California Music Festival in March. He has been named one of the celebrity chairs of the Met Gala in May, and he has a major role in a Spike Lee-directed film with Denzel Washington to be released soon after. But his life could be upended if he's convicted of firing a gun at Terrell Efron, a childhood friend who testified that their relationship had soured and a feud came to a head on the night of November 6, 2021. Efron testified that bullets grazed his knuckles. Since 1876, the Black Hills Pioneer has been a locally owned and operated newspaper. To read all of our stories, click here.
Now, you know, I had to go be nosy and go see this mama. Is this mama? Okay, that must be the mama. Okay, let me see. If I put the mama on up there. Oh Lord, honey, this Lord. That must be the mama right there. Yeah, honey. We sure is nose over here. But y'all, it has been a full schedule. Well, oh, I know I meant to let y'all hear that goddamn Snoop. Snoop, you out of here, son. We listen to this about Snoop. And then I'm gonna let y'all go.
Well, okay.
Like, what are you doing?
All right, Jess.
How you get up, sweet? How that happen?
That sounds great. Got up gay. I know what you're saying on that.
We going Snoop. We going to Yo. So all right, changing gears. Snoop Dogg. You remember Snoop? Everybody was upset.
You remember Snoop?
No, not
know who Snoop is.
Envy, I'm sorry. This
You're right,
man
Lauren.
threw me
No,
off.
you're right. Do we remember what people were even mad at 2 days ago? You're absolutely right. Because people move on so fast. You're right.
Ooh, skeptic is so fine.
All right.
So Snoop responded seemingly to the people that have been upset at him for performing at the crypto ball for Trump. Let's take a listen.
It's Sunday, man. I got gospel in my heart right now. For all the hate, I'ma answer it with love. Y'all can't hate enough on me. I love too much. Get your life right. Stop worrying about mine. I'm cool. I'm together. Still a black man. Still 100% black. Ball out. Till you ball out.
Yeah, so Snoop is so unbothered. I don't even know what else to say, but like, it's Snoop. He's unbothered. He doesn't care.
You still Snoop?
Yeah.
At the end of the day. And side note, Snoop looks like he has the most amazing fun on Sundays. I don't know if you've seen it. He had his whole family there, his aunts, his uncles, his nephews, his nieces.
Fun doing
They playing dominoes, they watching the game, they drinking, they dancing.
Yeah.
Snoop look like he having a fun time on Sunday. The only thing I would say is I wouldn't call what Snoop received hate. I would just say that people had an opinion.
Right.
You know what I mean? I wouldn't say that they were hating.
You know? Nah, the people was mad.
Yeah, but that's not hate. They weren't hating on him.
Not
hating
on him. Just like, they had an opinion and they wanted like answers like, yo, dang, but you said
They were disappointed.
Yes, disappointment is better. Disappointment is better. Okay. Well, yeah, he's unbothered. But moving on to another story here, somebody that spoke out recently, D Woods. So you guys remember?
Okay, so we already played that. Yeah. So that is Snoop's response to, I guess, the backlash, we're gonna call it backlash, I guess, to him performing for Trump. Snoop, baby, you can go ahead on with that nonsense, because if you was unbothered, sweetie, in that retrospect, you wouldn't even said nothing. You know that your ass, these people are done with your ass. And again, you'll have that white shit, but the nigga shit, unless it's some flip-flopping ass niggas like you. There are some like that. There are some flip-flopping ass niggas like you, right? So they will keep fucking with you, of course. That's what they do. But real ones, partner. Real ones, and be real surface level, sweetie. Hey, how you doing? Hey, how you doing? How you doing? Okay. Other than that, baby, you know, we don't, no, we ain't finna do all of that punking. We ain't finna do all of that. We are over it. And I know y'all don't know my song, but don't worry about it. It take you back, baby. I told you, honey, this is when you want to shoot and you want to move and shoot, move and photograph. This is what you put on. Hey. All right. Hey.
I love my man because he do me nasty. I like the way you are. 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 I yo tengo clase, me gusta el baile de cha-cha-cha, de cha-cha-cha. Dame tu cuerpo porque me gusta, bailo bachata, también merengue. En Puerto Rico se baila salsa, así se hace, vamos a gozar. Arriba, abajo, a la izquierda, a la derecha, para el medio, para atrás, para atrás, para atrás.
You gotta watch Zeus to know the song. Hey.
I can do real sexy walking, but of course I can show you two dancing. Know you had to skip a shade shoe blocking. Don't give a fuck if your man is watching. She looking for some shade of married. I love my man cause he do me nasty. Yeah. I love my man cause he do me nasty. I like the way you are.
Go Patrick, go Patrick, go Patrick, go Patrick, go Patrick, go Patrick. Hey. And I like number 15.
I like the way you are. I like the way you are. Me llamo Jocelyn, yo soy bien linda.
Let me find, let me show y'all somebody number 15.
Tengo clase, me gusta el baile de cha-cha-cha, de cha-cha-cha. Dame tu cuerpo porque me gusta, bailo bachata, también merengue. En Puerto Rico se baila salsa, así se hace, vamos a gozar. Arriba, abajo, a la izquierda, a la derecha, para el medio, para atrás, para atrás, para atrás. Arriba, abajo, a la izquierda, a la derecha, para el medio, para atrás, para atrás. I can do real sexy walking, but of course I can show you two dancing. Know you had to skip a shade shoe blocking. Don't give a fuck if your man is watching. She looking for some shade of married. I love my man cause he do me nasty. Yeah. I love my man cause he do me nasty. I can do real sexy walking, but of course I can show you two dancing. Know you had to skip a shade shoe blocking. Don't give a fuck if your man is watching. She looking for some shade of married. I love my man cause he do me nasty.
Yeah, I'm 6.
I love my man cause he do me nasty. I like the way you are. 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 I like the way you are.
Yo, hey. Make sure you do something good for yourself and someone else, baby. Make today a good day, tomorrow even better day. And guess what? I'm out of here, and so are you.